Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican parade service.
Oh, for Trump's sake.
Is that correct?
Literally not true.
I didn't ask you to interrupt me.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday to you. Bad news, the weekend is over. Sorry to be the one to have to break that to you. Yes, it's back to the old grind. Unless you love what you do. And then it's wonderful. Happy Monday. Happy Monday to y'all. Glad for the old grind. I'm tired. That's awesome, Brett. Have to right now welcome Kim R, who is first in chat. Kim, you know what happens. It's like you're a glutton for punishment, right? You're a habitual offender at this point. First in chat is going to get punished. You know this. You did it anyway. We're sentencing you to internet ownership. The rest of this morning, you are responsible for everything IP related. And one of the things is the seats. I'm just gonna pass that off on you. I'm gonna pass the seats off on you. So if you could fix those, Kim, that would be great. I am trying to get the seats to work. I tried. Honestly, that's why I was late. That's why we sat there and looked at the logo for a minute while I tried to get the seats to work. YouTube quota exhausted. Please wait a few minutes and try again. It's exhausted. It's done absolutely nothing today. I can tell you, YouTube has done nothing. Let me turn it off. Refresh. Turn it back on. Refresh. Go back to my dashboard. YouTube quota exhausted. Well, let's see. I didn't see. Apparently, Kim. Apparently, I'm getting told that you tried to pass the buck, and so let me look into that and see if that's the case. Hold, please. Hold, please. How could it be exhausted when I've done nothing? Clear the logs. Clear the logs. Now do it. Still exhausted. All right. Before we get started on our fun happenings today, we're just going to delete the connection to YouTube altogether. Boom. It's gone. It's gone. We're done. Done with the seats forever. No, just kidding. Well, we're bringing it back. Allow Lumia Stream to use actions. Sure. Yep. That's all good. Now we connect. Yes, we want the Recovery Addict channel. Continue. Lumia Stream already has some access. That's good. That's good. Connection successful. Okay. But is it fixed, is what I'm asking. Is it fixed? Refresh the changes. YouTube quota exhausted. Please wait a few minutes. I've got to say this is not me. This is not me. All right, screenshot taken. We're going to send that up the chain and figure out what's wrong with that at some later point. Right now, though, let's go back to where we are and see who is taking the fall for Kim R. R.A. Give my internet win to Mindy FS. We're going shopping for the day. Good morning, chat friends. It's been great. 27 months here with you. With love. From Belarus? I don't know. I don't know my flags. I don't know my flags. Somebody tell me where that flag is. Kim, I have no idea. You've got water around you? What flag is that? So Mindy FS, it's all you. Aruba, Jamaica. Ooh, I want to take you. Yeah, Aruba. I was close, right? Are they like neighbors? Same hemisphere at least. That's awesome. Kim, congratulations. Actually, so Mindy FS, congratulations. The internet is all yours. You were the winner today. All right. Kim says, I was watching RA and chatting in Broken Baker. Sorry. I just thought of something funny. Meg, member for 2 months, says, hello. Couldn't be here Friday. It was a birthday out. Love y'all. Meg, happy birthday. Happy birthday. Jade, member for 7 months, says, I took a break, but it's great to be back. Wonderful to have you here. Congratulations on your return. Kim is on vacation. Yes, she's rubbing it in. Britta Aller, member for 28 months. Another great month with great friends who love true crime. Love you all. Wonderful mods, friends, and RA and his wonderful family. Thank you, Britta. Appreciate that. Melissa P, member for 20 months. Okay, so I've got to say for Britta Aller, OG. And for Melissa P, OG. Going through a lot right now. Real life, kicking my behind. Miss chat so much, but love you all. Congrats, RA, a.k.a. Grandpa. Thanks for that. I'm happy about it, but the grandpa it doesn't sound right yet. Yeah, I have something to tell you guys. You know, I like to complain a little bit. I like to be a little bit of a grouch, right? The grumpy, get off my lawn guy when it comes to what the neighborhood and the towns tell me I'm supposed to do with my yard. I like yards. I like them looking good. I used to work in a lawn care business. Okay, I understand. A nice, trimmed, beautiful lawn looks great for the community. But when they tell me like how to decorate and when and why and everything else, I'm like, look, do you just want to buy the place and do it yourself, or can I just do my thing? So, full disclosure, I bought the flag. It's beautiful. No, it's not a cheap printed, screen printed one. It's the Valley Forge stitched design, though. So there's white stitches for the stars and everything. It's a nice flag. It's big. It's hanging right now in front of my house. Beautiful. Put it up. I used the weed eater around the edge, the bit of the lawn. I did everything. I cut down a few volunteer trees that were coming up in my bushes and trimmed everything back. I just made everything look really good, and we even cleaned it up before the parade. And I thought, this town isn't so bad after all, when you think about it. And so we sat out and we watched the parade. It was great. It was a good parade this year. It was really good. There were 0 Carolina squat trucks in it, which is how I rank parades. If there are squatted trucks in it, you're losing points. There were 0 this time, which was good because officially they're illegal in the state. So So it was all good. See, I rode my bike around a little bit in the morning, had some fun. The parade happened, and then I took a nap, and then my kids wanted to go downtown to the party. The whole Main Street area, the town hall, the stage. We've got bands there. We've got a little circus act. We've got some little kids that break boards with their feet and the hands. I guess a karate demonstration. It was wonderful. And I'm down there. I'm like, hey, this town's pretty cool. It's pretty cool. Got some pictures of all the occasions and the food and the festivities and the fun. Of course, it's like some traveling carnival rides that show up that are basically death traps on wheels. And they wanted to charge you $4 to borrow a potato sack to slide down their slide. And then you give the potato sack back. You don't even get to keep the potato sack. $4. I'm like, we're not doing that. I'm sorry. We're not doing that. I can get a potato sack for much cheaper. We can go use somebody else's slide for free. So we did not participate in the rides, as they call them. And here we are. It's getting warm. We've listened to the band. We watched the circus people. The juggler did a great job. Told the exact same jokes in the same order he did last year, but that's okay. They were still funny. And the silk dance people, they hang like a silk cloth from like a huge tripod or quad pod. What do you call that? And they tumble and don't hit the ground. That was good. We watched that, and then they announced it's time for the event you've all been waiting for, the collard eating contest. This is a contest where we invite members of the audience 18 or over to come up and subject themselves to collards in mass. and they allowed 8 men and 8 women to compete this year. And they have these collard greens, which I'm not sure if you know what collard greens are. I know a couple of you are a little bit misguided on this, but they're not good. They're not good. They're not good. And here I am, I'm watching, and they're like, we've got 4 men and 5 women. I'm like, come on, men, do better than that. You know, at least show up. I'm like, I've been here for 6 years, and I've watched this for 6 years. Like, do we have any other participants? Anybody else want to? And I'm like, should I? The idea is like, should I? And so I asked my wife. I said, do you think I should, throw my hat in the ring a little bit? It's a $100 prize for the winner. And she said, absolutely not. And the kids, including my daughter, like, Dad, no, please, no. They're like pulling on my hands. No. I'm like, but, it's for the town, I took a seat. I was contestant number 6. And against all the advice of my family, I sat down to have a eating contest, knowing full well that I hate the thing we're eating. Like, it's disgusting. It's wrong. It's just like it should not be consumed. Not for human. I wouldn't feed animals this. It is not good, in my opinion. 3.5 pints later, and by pints, we're talking pints of collards later, I'm like, I've come to the conclusion. The contest, we had 30 minutes to eat as much as we could. And you just stack the bowls up. You stack them. That's how you count. See how well you've done. They gave us I had a cup of ice water, to try to rinse it down. And they give you some vinegar or some chili oil stuff. I did the chili oil because I figure hot's better than collard. And so 3.5 pints later, I look over at Andy, who was a ringer from outside, by the way. He comes in from Raleigh area. I think he's from Apex or Cary or something. Comes all the way to Ayden once a year. It's the only time he visits our town. And it's the only time he eats collards ever. And he's like a professional eater. He currently holds the record at 9.5 pints of collards in 30 minutes. But it's not just how much you can eat in 30 minutes. It's how much you can eat in 30 minutes and keep down for an additional 5 minutes thereafter, after you stop eating. And I pretty much waved the white flag at about minute 22. I'm like, this has been a good run. I feel good about my contribution, and I will never do this again. But 3.5 pints of collards is respectable. I came in about 4th place among the men out of 5 or 6. I forget what it was. Andy did 6.5. It's a far cry from the 9.5 he set at the record a couple years back. But I did participate in the collard eating contest, and I won absolutely nothing other than the shame of my family. And I didn't even get also ran a trophy. So anyway, I just thought I'd let you know that happened. So now the town can stop complaining if I don't have my Halloween Halloween decorations up in time for Halloween, or if I have my Christmas lights up still from 2 Christmases ago, which I do. So there's that. Anyway. All right. That was my healthy food. They're not healthy. I don't know. There's the salt content in those things it's way up there. I don't know what they put in it, but it's like grass clippings and salt is what it tastes like. Anyway, good morning. Welcome, one and all. Good to have you here. We have to celebrate some birthdays today. So we'll do that. We'll do that first. Red Pen, thanks for this. Today's birthdays: Cheryl Ann B., Balo Bird, Pepper, Sherry C., and Clara. So we're going to sing to all these wonderful people, and by we, I mean all of us, everyone, wherever you are. Stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, warm up with the, if you will. La 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 la. All right, here we go. Happy birthday to you. Happy birthday, Cheryl Ann B, Baylor Bird, Pepper, Sherry C, and Clara. Happy birthday to you. Happy birthday, Cheryl Ann B, Baylor Bird, Pepper, Sherry C, and Clara. There are many wonderful days, but today is your special day. And I realize there are a million places you could be, and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor is ours. Hopefully you can turn some of the joy we feel back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. Happy birthday. And I guess have some cake, courtesy of Pantoufle. Happy birthday. One thing I would not recommend is eating greens. Welcome to the world of competitive eating. I've got more to say on this, but the greens they serve are not good. They're not good. They don't even look good. I mean, you can lay broccoli out on a plate. It's like, hey, that's sort of tempting. You can even stack up Brussels sprouts in a neat little pile. You're like, oh, that's cute. Like little baby lettuces, right? But they're not. There is nothing you can do to collard greens to make them look appetizing. To make you think, hey, let me put a forkful of that in my mouth. Don't do it. Don't do it. Happy birthday, all those who are celebrating. It's a wonderful day to have a birthday. All right. Drum solo coming up. You can all help me finish the birthday song. The song will stop, but the party never stops. Beautiful. Greeners, OG. Welcome to the world of competitive eating. It was not that I was full. Okay, I'm gifted in this area. I have a talent. Maybe it's a natural knack. Maybe it's, a God-given ability. But I can eat a lot of food, right? Surprise, surprise. I can eat a fair amount. I can pack it away. It was not a question of can I fit anymore. It was a question of I can't stand this taste in my mouth any longer. It has to stop. There has to be an end to this. I was feeling so good. I just to demonstrate, I did jumping jacks after I finished eating because I was feeling fine. Amber, how are you doing? Well, it would be better if everyone could hear you, but hold on one second. Testing, 1, 2. Are you there now? I'm still not hearing you, so hold on. Aha. Try that. Amber, what is speaker? Let's change the speaker. Call me back in just a second, okay, Amber? Okay, bye. Why is that not working? We'll try it again. We're plugged in. It's ready to go. Turn it off. Now you can hear. Amber, we can hear you now. How are you doing?
How about now? Can you hear me now?
Excellent. How are you doing? I turned it off and on again, as is the case with most tech. It fixed the problem.
Right. Yeah. That's typically the go-to. Yeah. I just wanted to say you're slacking because Red Pen has been trying to say in chat 10 million times, happy birthday to Angie Law, and you missed it before the song ended. So I was calling to say specifically happy belated birthday to Angie Law.
Angie Law?
Angie Law.
Angie Law, how did I miss you? Amber, since you're on the phone, if you want to just chime in with
No,
me,
I'm not saying bye. Happy birthday, Angie Law.
She hung up. Angie, she hung up. Let's sing one verse for Angie Law, if I can find it somewhere in chat. Happy birthday to you. Happy birthday to you. Happy birthday, dear Angela, happy birthday to you. That's all I got. That's all I got, Angie. I apologize. I missed it. I was so busy talking about the food I ate over the weekend and regretted that I just didn't see it. She added it in chat during the song. Okay, so Angela, go to the form next time. Yes, it helps if you submit it, usually the day before or earlier. That's the best. We need a shock collar. I've thought about that, but then I thought about who would have the button. Let's see. There was one, I just saw this just a second ago. Frida B. OG. This is great community. I have enjoyed all 29 months. No regrets, says Frida B. Obviously, you have not had collards. They're regrettable. They're regrettable. But I honestly would have kicked myself, if I moved away from this town and never took the opportunity to participate in their tradition of trying to eat collards collectively. As a group of contestants, we ate over 45 pounds of collards. I think they say a pound is a pint, is what they say. It felt like about 1.5 pounds to me, honestly. So I was thinking I was approaching that 5 pound mark of my entry. But anyway, Kimbers, Ohio. Oh, gee, no other place I'd rather be. Thanks. All right, thank you, Kimbers. It's awesome. Collard greens is a must side dish for something that starts with the letter F. The most traditional Brazilian dish, pork and black bean stew. Oh, man. You must cook them differently. You must do something. It's like lawn clippings. It's terrible for me. Kelly H., good morning. Good morning to you. Thank you for your generosity and super chat this morning as well. Stop with the collard greens hate. Okay. I feel entitled a little bit. I ate 3.5, over 3 pints. I wouldn't say I ate the full 3.5. I ate 3 full pints plus some of the fourth, which was considerable. I mean, even those who like collards, I think after 3 pints, they're like, nope, I'm done. Anyway, I tried. I really did try. Andy, though, he was a machine. He was just chowing down. There was another guy who was raising money for the local. There's a local Christian church that does a food bank that focuses on children, young families, families with children, and he was raising money for that. And that poor guy, he was stuffing it. I mean, he had to take it. He was so full he had to take his hat off to make room. I mean, he ate over 6 pints as well, but Andy beat him just by, a couple forkfuls. Wow, I feel sorry for him. He did not look happy. Amy P., you just need them cooked right with hot sauce and cornbread. I didn't know till afterwards I could have asked for cornbread. I thought it was just straight collards. Collards and water is what I did. Andy, he brought like a whole spread of different sauces. I think he even had ketchup there. He had everything you could possibly imagine to put on collards. He had there, his seasonings and his sauces and everything. I did not prepare. I was not prepared for that. No bellyache though. I was good. I stopped in time. Paula Mac, did I catch your anniversary message? I think I did. Did I miss it? I did miss it. Paula Mac, OG, member for 28 months, says, so much fun being a part of this community. I love the mods and all the friends I've made here. Britta, Greeners, and I must be in the 3 amigos at 28 months, for sure. Greeners, OG as well. Whoa, Jojo, member for 3 months. Hey, Ari, can you advise me on how to stop ads? They just cover the chat every 5-ish minutes, but not the video. Please and thank you. Do you have YouTube Premium? That's the only way I know. That's the only way I know to stop them. I do everything I can on my side to stop them during our live streams. That's the only other way. Melissa P., member for 20 months. Congratulations, OG. Britta Aller for 20 months. Jade came in earlier this morning. Member for 7 months. I took a break, but it's good to be back. Let's see. Kim R., member for 27 months. Give the internet away. OG. Meg, 2 months there as well. Congratulations. I think that's it. I think I got everybody now. I apologize if I missed somebody. Let's see. With that said, we've got some stuff going on with Judge Middleton. He's got a full docket this morning of some civil cases, and some of those might be a little bit funny. I mostly just like to watch him because he knows everybody. And so we're going to jump over there. We do not have a case today that we're following, but we're watching. We're keeping our ear to the ground for some stuff that may be coming up. If you hear one that's coming up that we think, I mean, by coming up, I mean, if somebody just got arrested in your town for some crazy crime, it's probably not coming up quite yet, especially if it's murder. Those usually take a couple of years, but if you know of a case that's about to go to trial, then hit me up so we can look and see if we can cover something. All right, Judge, how are you doing? Judge Middleton.
They're going to put her in the conference room in case we need to have you talk privately. I'm not afraid to have people come in here in the courtroom. You've never been here, but it's just me in a room with...
I have. I used to go there often. It's been a long time, but...
Okay, I guess so.
Ohio Gin, OG.
COVID,
and
yeah, I used to
Debbie,
see real people
Creative
in
B,
here
OG
on Monday mornings,
well.
but we still do almost all of our criminal cases live, but almost all of our civil cases are still remote. This particular kind of hearing is perfect for Zoom.
Yeah.
As you said, you're doing 3 or 4 hearings this morning without leaving your desk.
That's the best way. It all started with Daryl Brooks, says Ohio Gin. Debbie, the Creative Bee, said, I'm so glad RL has calmed down a bit and I can spend time with you again. Missed you all. Real life does have a way of getting in our way. So, oh, look, we've got some people here. Who's here?
No,
Good morning. Are you Patricia Hicks?
Yes, I am.
All right, this is Judge Middleton. I'm here in the courtroom.
Okay.
Also with me is the distinguished Matthew Kuipers from Bingham Farms. He's with the Rausch Sturm law firm. He's representing Synchrony Bank. They're suing you for $10,808.49.
Oh.
We also added in the court costs of the filing fee, the service fee, and the attorney fee of $75. The total amount they're asking for is $11,106.49. You filed a letter, which was pretty basic. We accepted it as an answer. No money at this time. Only have Social Security and Medicaid. So you don't have any money.
None at all.
So there's nothing
the fact
to
that you don't have money is not a defense to the fact that you owe money. If you don't have any money, you don't have any money. They can't seize your Social Security or your Medicaid. Do you have a pension?
No. Nothing.
Well,
all right.
Sounds like this will be a
We
write-off.
have enough in the bank right now to pay the house payment and the light bill and the car insurance, and enough that our food stamps don't quite cover our food, and that's it for the month.
All right, now a couple pieces of advice. You don't mingle your funds with your husband's funds. If he has money that he gets from...
Nope.
All right, well, okay.
Neither one of us.
All right, well, here's a couple ways we can go. You can simply admit that you owe the debt, and I'll enter a judgment, but they can't really collect on it. If you're not willing to do that, we can set up what's called a motion for summary disposition, where the plaintiff would simply argue that there is no defense stated and there is no issue of fact. You simply owe the money. That would entail you having to come back again. But if you simply acknowledge that you owe the debt, I can enter the judgment. If you don't wish to do that, we can set up for hearing on something called a motion for summary disposition.
Well, I am very illiterate in all of this, and so I'm going to ask what would be in my best interest.
Judge can't tell her.
Well, thank you for having the trust to ask me that, but I can't answer that. I can't give people legal advice. People often ask me in a criminal case, well, what do you think I should do, Judge? Think I should plead guilty or not? And in my mind, I'm thinking, well, yeah, this is a really strong case. You should plead guilty, but I can't tell them that.
Exactly.
And the same thing in a civil case. I can't tell you what I think you should do, but let me lay out the options. you don't really have a defense. You acknowledge that you owe the debt. You don't have any money to pay on the debt, and they can't collect from your Social Security or your Medicaid or even a pension.
Judge Middleton, can it just be dismissed?
That's not up to me. That's up to the plaintiff. They do sometimes have hardship cases, but
I tried to talk to them, and I couldn't get anyone to talk to me.
Your Honor, I don't have authority to dismiss the case. If the court's inclined not to grant the prior default, I guess I'll just request 60 days of discovery and time for motion.
All right. Yeah, she wasn't really.
I can't see you, and I couldn't understand what he said.
All right. Well, he looks good. If you could see him, you would know. But he says if you're not willing to simply admit the debt, he doesn't have the authority to dismiss it.
Okay.
This company hired them to try to collect on this debt, and he can't just dismiss it. He is astute enough to know that he's probably never going to collect any money here, but he has to proceed with the case.
Okay.
So if you're unwilling to simply acknowledge that you owe the debt, he's going to file a motion, and we'll reset this for 60 days from now. And if he prevails in that motion, I will simply say you owe this money, and I will enter a judgment in the amount of $11,106.49. Now, that is a statement to say you owe that money. But if you don't have any money, you don't have any money. But your circumstances could change. You could inherit money. You could win the lottery. You could find a gold coin in your backyard worth $1 million. I don't know.
Be nice.
Yes, wouldn't it all?
Yeah.
Somebody won the Powerball, and it wasn't me. My odds probably would have been better to win if I had bought a ticket.
Mm-hmm.
Yeah.
But two people won a share of a $1.2 billion. So I don't want to pressure you to do something you don't want to do. If you don't want to come back, you can simply acknowledge that you owe the debt, and we will do a consent judgment. If you don't wish to do that, we can set it for hearing for summary disposition 60 days from now.
You know, we live in Mendon, and I guess to come back, when they send me all the paperwork, I can't do anything over the computer. So I need to come back, and I guess we can come back.
Yeah.
Shall we?
All right.
That's what they want.
I don't really know.
All right, I'll continue this to November 10th at 9 a.m.
Thank you, Judge Wilson.
21 days to file motion for summary disposition.
This company's not going to be able to collect a penny, and they know it. Unfortunately, the lawyer has to go through the motions.
21 days to answer.
Okay, now, do I need to do anything?
Well, let me explain. They're going to file this legal motion, and they're going to file a motion that'll have a brief explaining why they're entitled to what they're asking for. You would have 21 days to file a written answer to that, but you don't have to.
Okay.
Simply a request that you appear at court, but it's very likely on that day that I'm going to grant their motion, and I'm going to make a finding that you owe that amount of money. And that'll bring the case to a close. But do you have other debts other than this?
Not that they're pressing us on.
Oh, that's good.
We had one prior to this, and because of the circumstances, they dismissed it. It was a small.
Well, they may consider that here, but they're not willing to do that at this point.
Okay.
All right, I
Christine
appreciate your being here.
Fortunato.
I'm sorry I didn't call to make sure you were here. We made a record that I thought you weren't here, and as a point of fact, you actually were. But we will continue this to Monday, November 10th at 9 a.m. for plaintiff's motion for summary disposition. And
So
I'll see.
Oh, I just need to show up. What time does the courthouse open?
We open at 8 o'clock. I get here about 7:15.
Okay, so I just need to be here like 15 minutes early or so.
Yes.
I don't need to reply to anything. I just need to come on the 10th.
Yes.
Okay.
Thank you. I got to go to my other Zoom quick, but.
All right, go ahead. We've got our next defendant.
Matt's like, I've got another case.
Is that your second one? No, we've got, I think, is Kelly James in here with the phone number?
Christine, congratulations on 25
All right,
months.
you stay where you are. Go ahead, Mr.
Awesome.
I'll be right back. Thank you, Jeff.
Ms. Hicks, you're good to go.
Okay, thank you.
Thank you. Okay, Nate?
Yeah.
Let me see if we can jump over to Warren County really quickly. Josh may have found us something. Josh has been hit and miss lately, as far as the bangers. Let's see. Josh, you're doing great, by the way. I'm just giving you a hard time. Warren County Common Pleas Court. Need room 3, which is right here. Let's jump over here. I think this is going to start in just a few minutes. This is, Josh says this is a hearing at 9:45 to see if the trial is still a go for tomorrow. So we might have a trial tomorrow in this court. I'd like to hear the hearing just to see what's up on this one. So we'll just sit here tight for just a moment. Defendant seems a little animated. Get back to my regular spot. We should get audio here in a minute when the hearing starts in just a couple minutes. Weebug, did you get the Facebook link about a case scheduled for October? I said it yesterday morning on Facebook. I struggle with Facebook. Amber knows this. Josh says the guy in back there might be a pro se defendant in the blue shirt with the beard. So we might get a twofer out of this one. Weebug, let me take a look at Facebook and see. Not sure where you would have submitted it. Just trying to connect. See. Wish we could listen in on this one. Turn the mics up. It's going to start here in just a minute. I couldn't find it yet. Jennifer Cockfield, member for 16 months. Welcome to the gallery. Thank you. Okay, looks like the judge is coming in. Here we go. Judge Oda.
This is the case of the state of Ohio versus Are we doing Rogers first? Raekwon Rogers, case number 25 CR 42768. Present before the court is Mr. Rogers, represented by Mr. Helbling. We have Mr. View from the prosecutor's office. We're here today for a pretrial. What's our status, Mr. Helbling?
We're going to set it for trial, but we want it to be heard on bond, Judge.
Okay.
Because there were a couple additional things that I found out when I came out of your chambers.
Okay.
Mr. Raycon's aunt and his girlfriend are here, and they brought the unit down with them that you had a question about, the ankle monitor. I think as we clarified to the court, that ankle monitor was removed up in Trumbull County by the people up there at the sheriff's office, I think it was.
Yes, sir.
My client wants to be heard on bond because he'd like to have the bond reinstated. Originally, he was going to be in court here on the 2nd of September, which was last Tuesday. That got vacated on the week before. And when it got vacated, he had planned to come down at that time. He doesn't have a driver's license. He did have a job when he was up there that he's now lost. But he'd like to address the court on a couple things with his bond, and he'd like to be placed back on bond, and he will show up.
All right, what do you want to tell me, Mr. Rogers?
First off, good morning, Your Honor. I was actually transported here from Trumbull County pending this indictment, sir, and I was transferred here on Wednesdays and had court there Thursday, so I missed court there because I was here, Your Honor. It's why I had a warrant there. So when I was placed on the ankle monitor, Your Honor, they finally caught up to me in the courts of Trumbull County. When they put me in the county, they removed the ankle monitor, cut it off of me. But the judge released me the next day because she seen that I had no intent of not coming, that it wasn't in my will to ever to be there at the time for court. So I asked, Your Honor, that you let me be back, released on
The other with the support cases that you have.
Oh yeah, yes, sir, Your Honor. Also, I have court pending right now I'm in the child custody battle. The mother of my child was recently deceased, giving birth to her last child. So I have a lot of obligated things that I'm obligated to be there for, as far as like my 2 children, Your Honor. And I asked that you let me back on bond because I had no intent of not showing up. I actually was in contact with my pretrial release officer multiple times and my public defender, my lawyer, sir. And I advised them that I would be here on my court date to get my release, my ankle monitor back on. Now, my significant other had to take off work just so she could be here. So I knew for a second we were set to come on the 2nd to court.
So here's where we're at, Mr. Rogers. I don't know about all of this because I have a lot of questions. And when I have questions on a situation like that, I'm not going to give you the benefit of the doubt. That's why I'm not going to release you today. So we're going to get it set for trial, get the equipment turned in. Ms. Carrillo, you can go ahead and get the equipment after court, after we're done today. You can go ahead and get the equipment. Let's set this for trial. Let's also set it for next week. Is he in our custody now, or is he going back to Trumbull?
My understanding is he's in our custody, which
I believe
means
he's being held on our charge.
I'm sorry, Your Honor. I didn't mean to talk over counsel, but to me, he's here on this case, and he's going to miss his court hearing dates on the other case that he could probably resolve pretty quick. So that's why we respectfully request that you reinstate the bond. He does have his aunt is here and his girlfriend is here. They drove all the way from Warren, which is almost to Cleveland. Yeah, which is almost to Cleveland. So if he was a flight risk, he doesn't have a driver's license, number one. So if he was a flight risk, I don't think we'd be seeing his relatives here. And as I indicated to you in chambers, they have been in constant contact with me. They've been calling. So the risk is extremely minimal that he won't show up from my observation on dealing with this.
But I don't know what he's charged with.
As you know, for a while. But I think he will show up. I know he will show up now that he has counsel. And giving him the bond.
So I have too many questions that are not going to be answered today by you and Mr. Rogers. So I'm going to set this next week. Okay. I'm going to have my community corrections officers look into all of this.
Understood.
We'll set it next week. We'll also get it set for trial. And if everything that Mr. Rogers is telling me is true, then I might consider releasing him. But he just got out of prison, he got arrested, he got a new PV, and it's not just are you going to show up for court. I also have a public safety element to this that I have to consider. So we're going to look into that. We'll see you next week, and we will see go ahead and get set for trial because we got a try-by date.
The try-by date is October the 17th. I have a week-long trial that week that is going to get continued, so I think we could set it the week of the 13th if we need to.
All right, Ms. Idle will get your trial date. So go see Ms. Idle, and she'll get you a trial date. We'll see you next week.
Okay.
State of Ohio versus Tyrone Allen. Are we doing something on this case today, Mr. Elter?
No, Your Honor. We would like to set this out for plea in 2 weeks.
Are they the ones that have the? Hold on. Are they the ones that have this?
Oh.
What's that?
Mr. Allen.
Oh, okay. All right. Where are we at on Mr. Allen's case?
Your Honor, Mr. Allen is considering entering a plea in this matter. Given the issues that we were discussing in chambers regarding the box and the locating of it and returning of it, we'd like an opportunity to do that so that he might be able to mitigate whatever sentence the court has for him.
Okay. Yeah, I want my equipment or my money, Mr. Allen. And the reason, usually I don't care about money in this sort of thing, but when I lose a monitor or when I don't get the money back from the monitor, what happens is you're punishing the next person up. So there's going to be somebody after you who's going to wear that monitor. And if that monitor is not available for that person, then that person's life is going to be more difficult because of you. So that's why I look at it that way. Mr. Elter sort of told you where I'm at on this. We'll set it in a couple of weeks and see where we're at.
Christy H. Welcome to the gallery. 3 months.
He does want to deal with it. He does want to have it resolved.
I just want to tell you why. And I'm not trying to give you no excuse. I'm just trying to tell you what was going on with me at the time. And if you want to sentence me right now, I'll let you sentence me. I just want to let you know what was going on with me, if that's possible.
If that's what you want to do, Mr. Allen, that's fine. But also, it's not that I'm not going to hear everything that you have to say, but I think what Mr. Elter is suggesting to you is maybe timing is key, and that if we get some of these issues with my equipment or the restitution resolved, the things that you're going to tell me I might be more receptive to if we get some of these things worked out. If you want to tell me your story and be sentenced today, absolutely you can do that 100%. But Mr. Elter, whoever is standing with you there behind you, they're all telling you, pump the brakes a little bit, and maybe this won't go as harshly for you as it might otherwise go.
Thank you, sir.
All right, I'll see you in a week or so.
Thank you, Your Honor.
All right, so let's take a quick break and get reset for Mr. Reefer's case.
I think that's the one we're waiting on. Wow. I would say that judge comes across as what you might call a hardline judge. I think it's the guy in blue we're waiting for right there. Last Poet, member for 28 months, OG. Gohari and CF Crew. What's CF Crew? Was the F a typo? Crew? Thank you very much, Les Poet. Britta Aller says, super chat. Thank you, everyone who asked about my dad. He's more himself than he was on Friday. Morphine can turn you into someone you're not. Oh, it can. The side effects are terrible. But, you know, going without is also terrible. So that's a difficult situation. We are waiting for Brandon Reefers to appear. He's the one we're hoping for. There's an idea, enforce the law. It's a novel idea. But I like what the judge said. He's like, look, yeah, I'm coming down on you hard because, you know, I lost, you know, you were put on an ankle monitor and you took it off and we don't have it back. And I'm mad about it. Why am I mad? Because it affects more than just, you know, we lost some money because we lost a monitor. No, it affects the next person who would like to be out on bond on a monitor because they don't have one available. It's an interesting viewpoint that way. What's the history on Brandon Reefers? I think he's pro se. We think. I said it a little more nicely than you would. Lived in Cincinnati for 8 years. The best, says Stephanie. Sunshine Sarah, OG. RA showed me how to create a name and add picture pack back in the day. Now I'm a YouTube pro. Just like that. Sunshine Sarah, that's awesome. What is pro se? Great question, A. Colburn. Pro se is basically means proceeding on your own. You don't have a lawyer representing you. You are representing yourself in court. In some cases, like in small civil matters, that's always the case. You can't have a lawyer. It's just person versus person. It's a very oftentimes unstructured way of proceeding. But for oneself in Latin, thank you, is you are your own representative, and no one else is going to stand there. You're not going to have a lawyer. So when you get charged with something, you get arraigned, and you're like, hey, judge, you get arrested, take to jail. You appear before a judge, usually fairly quickly, and they say, here's what we're holding you on. Would you like a lawyer? Or can you afford a lawyer? Do you have a lawyer? And if you can't afford or don't have a lawyer, a lot of places will say, we will provide a public defender, somebody who is paid by tax dollars to be your lawyer, because you don't know the process. You're probably still not even sure what's going on right now in an arraignment, or what comes next, or what your options are to file. Oh, judge is coming back. Here we go. Generally, it's not a good thing to be pro se.
Did we lose Mr. Elter?
Pro se and sovsit often run together, but sovsit
is the case of the state of Ohio versus
different.
Brandon Reefers, case number 24 CR 42165. Present before the court is Mr. Reefers, right?
Good morning, Your Honor. Brandon Reefers, very pro se, especially not on the record. Thank you for the opportunity to be here today.
And we have Mr. Nice on behalf of the prosecutor's office, Ms. Hyatt also on behalf of the prosecutor's office in different capacities.
Megan,
we are here today for a hearing on the motion to quash. As I understand it, the dispute is over bullet point number 2, which is the video from November 9th and 10th. Am I right about that, Mr. Reefers?
Yes, Your Honor. There's several points. I have an opening statement, if I may.
Go ahead.
Your Honor, this case began with something simple. I went on a date that didn't go well. I left. She was upset and called. That led to a stop. From there, things went wrong. When Deputy Simpson approached me, I asked what the stop was about. He didn't tell me clearly. Instead, within seconds, the situation escalated. A taser was pulled. We argued because I was trying to understand why I was even stopped. Once I realized he thought it was about alcohol, my response was simple. Okay, well, let's do the field sobriety test. That would have resolved everything. If I passed, I would have gone home. But he refused to give me that chance. That moment snowballed into everything that has followed. At the jail, my frustration came down to one clear issue. I asked loudly and clearly for a chemical test. I pointed at the camera, I said this was wrong, and I wanted it documented. That's what I've been asking for in these records, the missing 1:30 to 4 a.m. window when I was insisting on my rights and no one listened. Your Honor, if I'd been simply given the test, we wouldn't be here today. But the deputy certification lapsed, he couldn't run it, that was on him. At that point, the deputies at the jail had a duty to call someone else. They didn't. That's why I've been pressing for the records. That's why Mr. Sarver's here. That's why these subpoenas matter, because the truth of this case is simple. I wasn't given the test. My rights were denied. I've carried this for nearly 10 months. This is where it stops. Your Honor, I'm not here to play games. I'm here to defend myself. The subpoena is the only way to get the truth of what happened that night. Without this testimony and without the footage, I cannot present a complete defense. That risks due process, it risks fairness, and it risks justice. Your Honor, that's why we're here. I'm not asking for anything extraordinary, only the unproduced videos and for Mr. Sarver to explain the gaps. For these reasons, I respectfully ask the court to deny the state's motion to squash and allow Mr. Sarver to appear and testify so the truth can be heard.
Alicia, congratulations.
Mr. Nice?
Good morning, Your Honor. Your Honor, I filed the motion.
You don't have to stand up, Mr. Nice.
Okay, thank you, sir. I filed the motion to quash because it's my understanding that the defendant, Mr. Reifers, has been provided any video that we have relevant to the time period of his arrest or being booked into the jail, that there was no redaction, there was nothing withheld. From his opening statement, it sounds like he thinks there's something that exists that we haven't provided. My understanding is that that is not the case. The subpoena was very broad and general and asked for all video recordings, full, unedited, for a 48-hour period. Cruiser cam, body cam, mic, in-car, jail, booking, video, all angles, all durations. And my position, Your Honor, is that just causes an undue burden. It would amount to sort of a duplication of all video systems in the sheriff's possession for all deputies for a 48-hour period. And I think it's just too broad, considering that he's already been given the video that exists pertaining to the time he was in the jail. And also, I just wanted to, since Mr. Reifers is pro se, I also just wanted to make the court aware, Mr. Reifers aware of this motion to quash, that several of the items he has requested just do not exist. I did provide, on behalf of the sheriff's office, working with the office manager, Paul Sarver, who's present today, I provided him with the items that were in existence in the sheriff's possession, and I sent that to him by like a Microsoft Dropbox type link last week. So that's my position, Your Honor. There are additional subpoenas that have been filed and towards the end of last week, and after we get through this issue, I'd also like to speak on those matters.
We don't have a motion pending on any of that stuff, right?
We don't. No, I'll likely. No, it's a matter of just the items don't exist that are being requested, or the subpoenas have been sent to the wrong parties.
Okay. Mr. Sarver, if you could have a seat up here for me, please. Do you swear or affirm the testimony you're going to give at this hearing will be the truth, the whole truth, nothing but the truth? So help you God. Oh, is there anything from you on this?
No, nothing more at this point, Your Honor. Nothing.
Okay. So, sort of walk through this. Could you say your name and your professional address for me, and also your occupation?
That's Paul Sarver, Office Manager, Warren County Sheriff's Office.
All right. So you received a subpoena that we have broken down into 11 separate bullet points, and the first bullet point is chain of custody logs, audit trails, cruiser cam, body mic, in-car audio, and jail intake video. It's your position that these, that everything in response to that has already been provided to Mr. Reifers or does not exist, right?
Yes.
Okay. Number two, we'll talk about at the end. Number three, maintenance, malfunction, repair logs. It's your position that all of this stuff has either been provided to Mr. Reifers or does not exist, right?
Yes.
Same is true for bullet point number 6, which is incident reports and use of force reports, right?
Yes.
Also number 7, CAD logs, booking, jail logs, and written communications, right?
Yes.
Also number, wait, did I just say that? 8, which is emails, memos, or communications concerning the denial of the defendant's request for a chemical test.
Yes.
Those have either already been provided or do not exist, right?
Yes.
And number 9, internal duty to interview and review, to intervene, reviews and supervisory notes. Those are either non-existent or already been provided, right?
Yes.
And number 11, which is alcohol monitor placement orders and logs. Those either don't exist or have already been provided, right?
Yes.
You are prepared to testify on bullet point number 4, which is disciplinary records and administrative investigation logs, right?
I have those here.
And also number 5, which is intoxilizer certification and renewal records for Simpson McClellan.
Yes, those are yours as well.
And number 10, which is supplemental crash reports, photographs, or evidence submission forms.
Yes.
All right, when you say I have that here, is that?
It's all on a flash drive, and it's also what Mr. Nice has provided just like last week.
Okay. Do I have that somewhere?
I'm sorry, Your Honor.
What Mr. Sarver has on his flash drive, do I have that?
I have
Your
not,
Honor,
to be honest, I have not seen Mr. Sarver's flash drive.
These things were subpoenaed last week, and I provided them in advance to Mr. Reefers, and Mr. Sarver's subpoena was adduced to bring him to trial tomorrow, but I don't know, I don't think the court has those items.
Okay. I have a lot of flash drives, files, and so forth, and what probably makes the most sense is for this, we just add this to the we'll call it Exhibit 9.8.2025, which is electronic data provided to Mr. Reefers. What day did we provide it?
Your Honor, I believe it was...
Just ballpark it for me.
The 4th, September 4th.
On or about the 4th. Okay. So, Mr. Reefers, without going into bullet point 2, we're sort of saving that to the end because that seems to be our point of controversy. Do you have any questions to Mr. Sarver about any of the documents that are on any other of your bullet points?
Yes, Your Honor, I've got a list of questions.
Okay.
Do you want me to go up there?
You're fine at your seat.
Okay, thank you. Mr. Sarver, you are the public records custodian and office manager for the Sheriff's Office, correct?
Yes.
You personally responded to my records request on November 25th, 2024, correct?
Yes.
That request was submitted in late November 2024 for all jail intake and related records, correct?
I have that right here, actually. Would you like me just to read the request?
I don't even have a copy of that request. It never came back to me when I initially requested it back in January. That was also one of the items that we were missing. Okay, do you want to look at what Mr. Sarver has in front of him?
Yeah, if you can read what the original request was.
Why don't you go look at it?
Okay.
Do you want to also look at it, Mr. Nice or Ms. Hyatt?
Yes.
He didn't keep a copy of his own request? Hey guys, if you're asking about trials that are months away,
Hold on a second.
We can't decide what we're watching until basically the week of. I mean, we can plan for it, but everything moves. So I just don't have an answer for you. We planned on Brian Koberger.
That's just the list of the video footage that was sent.
We planned on Corey Richens a million times. We planned on Sarah Boone a million times. Finally got that one.
All right, so we're going to call this Courts Exhibit 9.8.2025-B. And Mr. Sarver, are these your only copies?
No, these can be given out.
Okay. So what we'll do is, Mr. Sarver says that this is not his only copy. So after the hearing, Ms. Kuroko will scan all of these documents, the exhibits, and we'll send them out to everybody.
Okay.
Thank you.
Okay? All right. Questions for Mr. Sarver about Exhibit B?
Yes, Your Honor. Okay. So on that day, I never received a copy of the original request from your systems, correct?
I do not believe I attached that to the email.
I'm sorry?
If you could speak up a little bit for him.
I did not attach the request to the email, just the records requested.
Thank you. All right, and on November 25th, you sent me a download link for the video footage, correct?
Yes.
That package included an 8-page offense report, several jail intake video clips, and Deputy Simpson's patrol car video, correct?
Well, he's looking at this.
Yes, it did.
Austin Drummond is
I
probably
applied
going
the
to
very
be
next day, November
2027.
26, stating the traffic stop clip had no audio and that the bookend and Sallyport clips would not play at all, correct?
Refresh your YouTube.
Do not have your response.
It was submitted last week with Exhibit A, including all the emails in there. We responded back on that.
Oh, disregard that. I do have your response, Treasurer.
Thank you. Your response on November 26 acknowledged that the body mic was not activated and the only audio was inside the cruiser, correct?
Yes.
You also told me that the jail intake clip requires a special VX player program to open, correct?
Yes.
Wait, Mr. Sarver, are you reading from a document that is not Exhibit B?
It's part of this. It's part of the.
Part of Exhibit B.
Yes, this is all its packet.
Okay, go ahead. Ms. Coco? Go ahead, Mr. Reeves.
After that, you sent me a link through the Model T transfer system, but that link only contained photographs, not the missing jail intakes, correct?
Yes.
And after November 26th, you provided me with you never provided me with any functional or complete jail intake footage from 1:30 to 4 a.m., did you?
No. The player was attached to the original link that had the videos in it. The player was attached as well.
The player was attached to it, but the missing video from 1:30 to 4 a.m. was not included.
There was no missing video. You requested bookend video.
All bookend video.
Video of traffic stop, bookend, and jail reports.
Correct. Okay.
The word all's not in there.
Okay. On January 3rd, you told me you were not the custodian for the dispatch records, correct?
January 30th?
January 3rd.
3rd.
Was again when I requested the videos and stuff, the 911 call documenting that Roberts called Simpson.
This is a new.
Okay. What are we identifying? We're going to call this 9.8.2025-C. What are we talking about here?
This is another request and my response, email response.
What's the date of the request?
It is 12/24/24.
Okay.
And my response is 1/3 of 25.
All right, go ahead.
Later in January, I again requested the 1:30 to 4 a.m. jail intake video, and on January 24th, you replied there were no records responsive, correct?
Later in January?
January 24th.
He's doing okay for a pro se, but it's one thing to be pro se in a hearing, it's another thing to be pro se during a trial.
This is a separate request and email response.
We're going to call this 9.8.2025-D. What is this?
This is a request for a phone call recording from Deputy Roberts to Deputy Simpson sometime between 1:30 and 4 in the morning.
What's the date?
January 23rd.
All right, go ahead, Mr. Reefers.
Lady Draconis, thanks for stopping by. Enjoy work.
What was your last question?
So then later in January, I again requested the 1:30 to 4 a.m. jail intake video. And on January 24th, you replied that there were no records responsive, correct?
This request says phone call recording from Deputy Roberts. He advised he made a phone call from jail to Deputy Simpson on 11/10/24, sometime between 01:30 hours and 0400 hours, requesting that Deputy Simpson, and then it's cut off. There's no request in there for video.
But you responded that there's no records response to that, correct?
Correct.
And then on May 12th, 2025, I submitted a detailed written request again for the 1 a.m. to 4 a.m. jail intake videos. You received that, correct?
I did. I also have that request here.
Okay, we'll call this E. What's the date of this request?
It's 5/12/25. It's a request and several documents in response to the request.
Okay.
So on May 12th, 2025, when I submitted the written request again for the 1 to 4 a.m. jail intake video, you received that, correct?
I did.
And on May 14th, you marked it as duplicate request, correct?
guys. It's doing okay.
I don't believe I have the email response to that.
You didn't respond? That's also a problem.
Do not have the email response to that.
So is there jail intake video from 1:30 to 4 a.m.?
There is not now.
Okay, what happened to it?
So when the initial request I got, which was the first exhibit, was for book-in. So I archived all footage from the time that he walked into the jail until the time that he made it to a holding cell.
What does that mean? It's a practical matter.
To me, as far as book-in goes, that is it. Once they hit the holding cell, that's it.
So what did you do? As a result of his request, what did you do in your system to preserve, make available, whatever you did, what did you do?
I did what's called archiving. I archived the footage from every camera that he appeared on until he arrived in the holding cell.
Okay. So that includes booking but not intake, right?
That includes the intake from the sally port to the search room, through the booking area, into the holding cell.
Okay. So is there footage of the intake from 1:30 to 4?
There may have been at the time, but it's gone now. The retention is about 30 days.
I'm still confused. So you get a request from Mr. Reefers for the intake video from 1:30 to 4 a.m.
Not initially, no.
Okay. You got a request from Mr. Reefers for some amount of video. And then you archive that video and then it's gone?
No, I have the archive footage up until I believe it's 1:30. And that's all I initially archived and provided. And then he sent another request. The next request wasn't until May for the video. And by then, there's whatever was not archived for that date was gone.
Okay, go ahead, Mr. Reefers.
Okay, so on May 14th, then you marked it as a duplicate request, correct?
Yes.
Okay. So if there was video from 1:30 to 4 a.m., you just didn't save it. Is that correct?
I'm assuming there was. I never viewed it. I would like to add that there is no audio on any of the jail video.
Okay.
If that matters.
I'm sorry,
There's no audio on jail video.
So this would have been, if this happened November 9th, it would have been deleted, auto-deleted or something like that by mid-December, is that right?
Roughly 30 days, yes. 30 days after.
Okay.
That's crazy. That's a short retention time.
Your Honor, that's what takes me back to the original request back in late November when I started requesting this material, then again in January, again in May. So going back to November 25th, the Axon link you sent did open, but the files themselves would not play without special software, correct?
The software was included, it is correct, yes.
Right, but it had to have that special software to play.
Had to have a player. Yes.
All right, when I attempted to open them, there was no audio and several clips did not play at all, correct?
For the jail video?
Correct.
It all worked for me.
There's no audio, and then several of the clips would not play at all, is what I responded to you on November 26th.
There is no audio on any jail video anywhere in the jail, ever.
That's fine, but what I'm saying is November 26th, I responded back to you saying the jail videos themselves would not work. Is there another link for those videos? That's what I specifically requested back in November.
Is there a question attached to that, Mr. Reefers?
Yeah, that was, when I tried to open them, there was no audio. Several of the clips would not play at all, correct?
I don't know if you could play the clips or not.
Did I email you and say, hey, these video clips are not working on November 26th? And we had a conversation about the links not working?
Let's see. It says, do you have any other links to the videos? The one video of the traffic stop does not have any audio, and the attachments for the bookend and Sallyport video clips do not work at all.
Yeah, thank you.
Which exhibit are you reading from?
It's the first one, I believe, from 11/25.
Is that, which exhibit is that? Do we know?
The first new one.
We need to be marking them as we go along. Can you just write on your little post-it note, we'll write A, B, C, D, and E?
Okay. Oh, can't get the pen to work.
What's that?
Pen doesn't work.
There, try again.
Judge fixes.
Those are very high quality pens.
Paid for by tax dollars.
So that's it.
Does it work now?
It does.
Okay.
That's A.
So you lied under oath.
Your Honor, also, can we make, once he's marked those, can we make a record of, so we know which date is associated with which exhibit?
I think the lady is
I think the only one I don't have
Counsel
is
for
A. I don't have a date on A.
don't?
No, I'm sorry, B.
for the union police officers.
But we'll run through them at the end. A is the electronic data provided to the defendant on or about 9/4. That's
Okay,
the
that's
thumb
the
drive.
USB, okay.
B is a records request dated, what's that date?
12/24. 24.
12/24/24. C is dated 1/24/25, right?
1/23.
1/23/25.
I believe my response was 1/24.
Okay, let's go by the request date on all of these. So D, what is the request date of D?
Was that the 5/12?
I had D as 1/23/25.
That's what I have, but he said 1/23 for C also.
There are two.
Oh, okay.
There are two for that same date.
So C is 1/23/25, D also 1/23/25, E is 5/12/25, right?
Yes, Your Honor.
Okay. All right, go ahead, Mr. Reefers.
Thank you, Your Honor. The Model T transfer link that you sent me contained photographs, but no videos from 1:30 to 4 a.m., correct?
You mean the Move It application?
Yeah, however you say it, the Model T, Move It T, or whatever it is, the link you sent?
That I don't know because the links expire. That's a county-owned program, and the links expire after I send them.
And how long, when do the links expire on that?
That's a county program. I don't know.
But through that, it's only photographs. There's no video sent through that.
I can't confirm that. I don't know.
Do you not have the records of what you sent me on that day?
I sent you on a county link that expires. I don't have access.
So
it's not my
have
program.
access to that again.
It's not my
So
program.
there's-
I have access to it.
I'm sorry?
Not the records that were sent months ago.
You don't have access to it anymore?
I have access to the records. I don't have access to the program that sent them.
Okay. On that Move It or Mobile T, however you want, the links in there, there was no videos from 1:30 to 4. It just had photographs, correct?
I don't know. I can't confirm that. I don't know.
That's fine. On January 23rd, 2025, the prosecutor produced CDs of jail intake clips. You were involved in supplying those to her office, correct?
Yes.
Those CDs ended around 1:30 a.m. and contained nothing from 1:30 to 4 a.m., correct?
Yes.
And you understand the missing time frame is when I was requesting a chemical test and when Deputy Roberts called Deputy Simpson. Yet no video has been produced for it, correct?
I don't know that.
You don't know if any video has been produced from 1:30
I don't know what
a.m.?
you requested during that time frame from a deputy.
If that's, I'm telling you that's what happened. I'm asking, was the video produced from 1:30 to 4 a.m.? Did you produce a video?
I did not.
Okay. All right. If the jail has footage, it has not been produced. If it does not exist, can you explain why there's no records covering intake from 1:30 to 4 a.m.?
There were at one time. They were not requested.
This is exactly over here, Your Honor. They had it, but now they're not providing it.
It wasn't requested.
I don't have any other questions, Your Honor.
Any questions for Mr. Sarver?
Yes, Your Honor, I just want to make sure I clarify a point. Mr. Sarver, is it correct to say that Mr. Reefers was booked in prior to 1:30?
Yes.
And is it correct to say that your understanding is when he asked for the book-in video, you provided all video in which he was booked in?
Until he went to the holding cell.
Okay, and you consider once you're in the holding cell, the book-in process is over, correct?
Yes.
Was he in the holding cell from 1:30 to 4, this time period he's questioned you about?
It's possible.
Okay, but is it fair to say you don't consider that time period to be part of the book-in process?
No.
Okay. And so when he asked you for book-in videos, you were excluding in your response that time period where you're just sitting in the holding cell, correct?
Yes.
Okay. No further questions.
All right. Anything based on that?
Yes, Your Honor. So if I may, is there a department policy that you know of, or who gives the authorization on what videos you clip? When somebody requests it, should you give them the entire time? Because I've only got 1 minute from when I went into the holding cell.
I provide what is asked for,
How do you
and
decide?
nothing more, nothing less.
With nothing more, nothing less, why didn't you provide the entire clips?
I did until you went to the holding cell.
Why didn't you provide the entire clip while I was in the holding cell?
I would have if it was requested.
It was. All jail intake videos requested in November and again in January, explicitly in May, calling out those exact time frames. Even in January, I specified I wanted the jail intake videos from 1:30 to 4.
On the original request, timeframes are not listed. It just says book in video. That's what I provided. We often get requests that I provide something and there's clarification. I did not receive any clarification.
Is it your standard practice when you respond that you include the original request? Is it a department policy you have to return?
Not policy,
request? No. Okay. Is it policy that you must retain all video clips?
Yes and no.
Okay.
Each type of video has its own retention.
All right. And then I go back to again on January 23rd. I requested 1:30 to 4 a.m. jail intake window and phone records. And you respond on the 24th. No records response. May 12th, I specifically asked from 1:30 till 4 a.m.
Mr. Reefers, we might as well go ahead and start practicing for tomorrow, okay?
Yes, Your Honor.
Which is, when it's your turn to ask questions, no big long statements offering testimony, just ask questions.
Yes, Your Honor. So there is no video you provided to me from 1:30 to 4 a.m., correct?
No.
Thank you.
And by the time he specifically requested 1:30 to 4 a.m., those records didn't exist anymore because they hadn't been archived, right? Any other questions for Mr. Sarver?
No, Your Honor.
Mr. Sarver, if you don't mind, I have you wait around with your paperwork so that Ms. Kurilko can go through with you. Or do you have all of that electronically?
I could scan it and send it.
I mean, she's going to scan it, but if you save her the scan time, but it sounds like you can't do that, so. I mean, you didn't print that from an already electronic copy, right?
I did, but it's saved in various locations.
All right, so we don't have anything going this afternoon. Ms. Kurilko can get all that scanned. All right.
Would you like me to just leave them with her?
Yeah, why don't you hang around so after the hearing you can explain to her what we got. We got the exhibits labeled and you guys can go through them. Then she'll scan them. We'll make a link available to everybody later today.
Your Honor, on that same note, the items that, the electronic records that were provided to Mr. Reefers, Exhibit A, I have those on a thumb drive in my office, or I have like a OneDrive link. I can provide those to Ms. Kurilko as well. I don't have them with me, but...
Well, Mr. Sarver has a thumb drive with all of those on there that we're going to keep.
Gotcha.
If I can leave.
Okay.
Gotcha.
All right. Because everybody has that except me, right? Right, Mr. Reefers?
I'm not sure. What are we?
We're talking about the data that was provided to you on or about September the 4th.
Provided me an email link with 4 zip files. That was what I received on the 4th.
Okay. All right. So if you could just hang around. All right. Anything else on that, Mr. Reefers?
I've got a closing statement, Your Honor, and then I'll submit my packet.
Okay. Well, we're still dealing with evidence issues. We're not ready to go to closing statements. Mr. Nice, anything else evidentiary-wise?
Your Honor, if I may, outside of my motion, there were 2 other subpoenas issued.
You can take that with you.
2 other subpoena ducis tecum that were issued. They've not been served on the Sheriff's Office staff, but I wanted to raise the issue while we're here.
Okay.
Because it again asks, one was sent to a Deputy Roberts. I believe he's a corrections officer, Roberts. He's not been served with this. He's not an employee of the Sheriff's Office anymore. It asked for his personal phone records and call logs, all text message, all his personal or landline calls. So 2 issues. He's not
You can sit
employed.
down, Mr. Sonny.
He's not employed by the sheriff's office, so he's not received the subpoena. Secondly, he would not be the entity that would have the records. He wouldn't have landline records, or he wouldn't even have his own. He may have his. He doesn't have a work-issued phone. I just want to make the court aware, Mr. Reefer's aware, that CO Roberts has not received that subpoena. He won't be responding to it. Similarly, Deputy Jack Simpson, he's present today, Your Honor. Same subpoena for all personal calls, work calls, landline calls, text messages, all records of all communication between Deputy Roberts and or CO Roberts and Deputy Simpson. But I just want to make the court aware, Mr. Reefer's aware, that sort of 2 issues. One, there's no record of these. I believe Deputy Simpson will testify that no such phone call was placed. But 2, he doesn't possess the records. It would be the Verizon or the telephone company. He doesn't have records of all those calls, so he can't respond.
Right?
He would have the phone, yes, and
just like anybody else, he could go back through his.
He can go back and look at sent and received calls. He can go back and see take screenshots of text messages, but he'll testify that none exists. I just want to make the court and Mr. Reefer's aware in advance of the trial tomorrow.
All right. And Deputy Simpson, come on up.
On the issue of personal calls.
Hold on. Let's go ahead and get this sifted through as we go. Do you swear affirm the testimony you will give in this hearing will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right. Have a seat up here. Go ahead, Mr. Nice. I cut you off.
On the issue of personal cell phone records, I believe Deputy Simpson will testify that at that time he only had the work-issued phone.
Okay. So we are sort of now on to the. We're done with the subpoena for Mr. Sarver. I just have to look at all of that stuff and rule. But we're clear that the records for bullet point number 2, even though your motion to quash said undue burden, it's not really undue burden because if we narrow it to this one issue, 1 to 4, it's not an undue burden, but it's no longer in existence, right?
If we narrow it to 1 to 4, and if we narrow it to the jail video only, which the subpoena was much broader than that, but if we narrowed it just to that, those don't exist anymore based on Mr. Sarver's testimony.
Even if I didn't limit it to 1 to 4, if the records weren't archived by Mr. Sarver, they're gone, right?
That I don't know. I don't know all the retention schedules for all the various types of records that Mr. Reefer's requested. I didn't look into it that deeply, but he requested all body cam, all cruiser cam, any and all video in and around the sheriff's office or the jail, or all video for those 2 days. So there may be other video that has different retention schedules.
Is there any video for those nights that have been requested, Mr. Sarver, that still exist from 1 to 4:30? I'm sorry, 1:30 to 4.
There possibly are for cruisers around the county, various places.
Okay, I'm talking about for the jail only.
Yes, sir.
All right. All right. Could you state your name and your professional occupation and your address, professional address?
My name's Jack Simpson. I'm a sergeant for the Warren County Sheriff's Office, and the address is 822 Memorial Drive.
All right. So you were involved in the arrest of Mr. Reefers, right?
Yes, Your Honor.
And Mr. Reefers is sort of alleging in his subpoena that there was some sort of phone call between you and CO Roberts. You're sort of familiar with that, that's his position, right?
Yes, I'm aware of the allegation.
All right. Was there a call between you and any of the staff members after you left the jail?
None that I recall, no.
Okay. All right. Mr. Reefers, do you have questions on that?
Yes, Your Honor.
Oh, wait. We talked about a work cell phone, right? You had a work cell phone that night?
Yes, I do have a issued phone, but my phone is issued through Deerfield Township because I'm stationed down there at that post.
Okay.
So they provide our phones for the supervisors.
All right. And so on November the 9th, do you still have, can you go back and look to see if there was a call on your phone?
I went back and looked through my call log, and it only saved up until December the 24th.
Okay. Mr. Reefers, go ahead.
Your Honor, that's exactly why we need these subpoenas to ensure that this phone call happened. If Deputy Roberts is no longer working at the jail, that's why these subpoenas are critical to show that this call took place. I'm assuming is this time for me to ask him questions?
Go ahead.
Here? So we're just dealing with just the phone calls, correct?
What else are we dealing with?
There was still requesting internal memos from the department because being a sergeant refused the chemical test. Somebody within the department higher up had to know about this. That's what we're after as well, as the internal memos going, why didn't somebody address this when a chemical test was requested and denied and refused by the arresting deputy?
All right, you can go ahead and ask Deputy Simpson that if you want.
Thank you, Your Honor.
Is it Deputy? Sergeant? What is it?
It's Sergeant.
Okay, Sergeant. Go ahead and ask Sergeant Simpson that.
Thank you, Your Honor. Okay. Sergeant Simpson, on the night in question, on November 9th, when you stopped me, what was the PC for the stop?
Well, the original call I was in the area was for the call at the Old Farm address where they alleged that a disorderly intoxicated subject was trying to get into the house. And then as I'm coming into the area, I pass you sitting at the stop sign at Farm Field and Homecrest, and I turn around and get behind you, and you made a left turn without signaling, and you sped through the neighborhood at a high rate of speed. And then when I initiated my traffic stop, before your car came to a complete stop, you had thrown it in park, and the car lurched, and that's where I'm at for the PC.
So there's no statutory violation that you were initially stopping me for. You were
Your Honor,
stopping
can I
me
object just on the basis that it doesn't relate to the subpoena? I know he might be building some foundation, but I just don't see how it relates to the call, if the call exists or not.
I do think it gives me a better sense of the timeline, which I'm a little fuzzy on. Everybody seems to have a better grasp on the timeline than I do, so I'm going to allow that for that limited purpose.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, let's not dive too deep into it, but let's
Yes,
hit the high notes.
Okay. Thank you. So you were stopping me because of the call, not for a traffic violation, correct?
Well, I stopped for both reasons, because I had reasonable suspicion for the call, because you're the suspect in this disorderly subject call, and then the observed traffic violations. So I stopped you for both reasons.
How'd they know he was a suspect?
Okay, but you didn't write any citation or inform me of the stop while you were up at the vehicle, correct?
I heard, why did you say
You didn't inform me when you stopped me what the reason for the stop was. The initial first thing you said is, why did your friends call? Is that correct?
I was asking you, because that was my first, that's the first order of taking care of that business.
Okay. And then when we get out of the vehicle, and within 6 seconds of me asking, what am I stopped for? You grabbed my hand. Then you said you had one resisting. So at that moment, is that when you arrested me?
So when you got out of the vehicle and grabbed your hand, it was because you had what appeared to be a knife. I seen the clip that appears to be a typical pocket knife, which turned out to be a firearm that you had in your pocket. So I was grabbing you per Terry stop to make sure, for my safety and yours, I was going to detain you to remove that knife for my safety and yours.
Did you articulate that to me?
Not at the time, you didn't give me the opportunity.
And when you stopped me, I told you very clearly up front, I'm a retired state trooper. I've got my secondary weapon. We got out. You grabbed me within 6 seconds. I'm just wanting to know, in that 6 seconds when you grabbed me and said on your radio, I have one resisting, were you placing me under arrest at that time?
For obstructing, yes, you're prolonging my investigation by pulling away from me.
So I was under arrest at that moment?
Yes.
For obstruction?
I was arresting you, yes.
Okay. And I was under arrest for obstruction. Okay.
6 seconds into the stop. Sergeant's spinning on his lying chair.
Okay. And then once we'll go past it, we'll stick to the scope here. I'm sorry, Your Honor, I'm kind of thrown off on this. After the whole situation, we go to the jail, all that. Did Deputy Simpson call you your cell phone, your work phone, or did he call you through radio communications for the test?
Deputy Simpson.
Did Deputy Roberts, I'm sorry, did Deputy Roberts call your cell phone, your work phone, or through radio communications?
Not that I recall.
Okay. Again, Your Honor, this is why we need the request, because Deputy Roberts is the one that stated he had called. The missing video is the time I'm sitting there telling them, hey, my rights are being violated. You guys have a duty to intervene and secure another operator to give me the option to secure this exculpatory evidence. Those deputies didn't do that. I made such a big deal that that's why they wrote their name down on a piece of paper for me. That's what we're here for. That's why these subpoenas matter.
Okay, do you have more questions for Deputy Simpson, or is that all, I'm sorry, Sergeant Simpson, or is that all for Sergeant Simpson?
That's all for now, Your Honor.
Any questions for Sergeant Simpson?
Yes, Your Honor. Sergeant Simpson, do you know all of the COs that work in the jail?
No.
Do you know who CO Roberts is?
No, actually when you're referring to Deputy Roberts, I thought we had a Deputy Roberts that worked here 3 years ago. That's who I thought that it was talking about. You know, it was confusing.
Do you recall any CO ever calling you, asking you to get some sort of chemical test at the county jail?
In my 23 years of doing this job, I've never, taking people to jail for OVIs and stuff, I've never had a CEO call me saying that a prisoner wanted a test, especially for an A1A section that I charge him with. None's required by the state of Ohio.
Okay, and just to clarify, during the time period of the arrest of Mr. Reefers, you had one cell phone?
Correct.
And that was issued to you by Deerfield Township?
That's correct.
Okay. No further questions, Your Honor.
When was the last time that you laid eyes on Mr. Reefers that night?
The last time I saw him was when they left the scene to transport him to jail, when Deputy McClellan transported him to the jail.
So you were still at the
scene on Homecrest, yes, sir.
You never went to the jail?
No.
And you never had any contact with anybody about Mr. Reefers later that night?
Not about requesting about this breath test.
Did you have any contact with anybody about Mr. Reefers later that night?
Not from the jail.
Did you have any contact with anybody about Mr. Reefers later that night?
Just the deputies I was working with and stuff like that was working the case with, but nothing in particular about him.
What did that consist of?
We were just talking about the different charges, how we're breaking up to doing the paperwork and the reports and stuff.
All right. When you say talking, face-to-face, text?
Yes, talk face-to-face, in person.
Okay, and when was that?
From this time at the incident until we got back to the office, was doing all the paperwork, doing the evidence, putting the guns in the evidence and stuff like that.
All right, so who all participated in those conversations?
It'd been myself, Deputy Peters, he helped me do the report and did the evidence. Sergeant Kaido.
They should have body cam. You should be writing this down.
Sergeant, or not Sergeant, Deputy Carter, because she did the crash report. And
You should
that's
be
all
writing this down and ask for a
All right,
continuance.
any questions based on those questions?
Judge is trying to help him
Yes,
out.
Your Honor, just one or two more questions. Fine, if I can have just a moment, please. And Deputy Simpson, is your intoxilizer certification still active?
No.
And then you said in your 23 years, is that correct? You've got 23 years?
Going on 23 years next week.
And you said you've never had anybody from the jail call you on a defendant requesting a chemical test?
Correct.
Okay. And how many of those OVI arrests where you arrested people did you not give them the option to take a chemical test?
Objection.
I don't keep, I don't know.
Have you ever denied anybody the option to provide a chemical test?
No, not if I offered it to them.
Not if I
Not
offered
if
it
you
to
offered
him?
it to them. Doesn't your department standardize that you should offer the test?
Well, it depends on the situation. With your behavior and the way you was acting that night, I was not going to handcuff you and deal with you anymore due to your turbulent behavior. And all I charged you with was the A1A section. If I was charging you for per se level, that would have been a different story, but I charged you with the A1A section, so I do not need to give you, by the state of Ohio standards, I don't need to give you a breath test.
But you do have a duty to collect all exculpatory evidence, don't you?
I collected the evidence that I needed for the charges that I charged you with.
You collected all the evidence?
Well, I had enough what I needed to charge you with the A18 section of the 451119.
What I'm getting at is there's a standard field sobriety test. Had you just told me what you were doing that night?
I'm sorry, start that over.
I said you have standard field sobriety test. Had you just told me what you were doing that night, we could have done field sobriety and resolved it.
I'm going to object. I just feel like we're just getting into the evidence of the case that's pending for tomorrow.
Overruled. Go ahead. Answer if you can.
Well, due to your behavior, there's no way I was going to try to give you a standard field sobriety test by unhandcuffing you due to your behavior.
And you're establishing that on the first minute and 6 seconds roughly of stopping me?
Yeah, based on walking up to you, you're punching the windshield. When I ask you a question while you're sitting in your car, you start yelling and telling me you're a retired trooper, which I found out later is not true. But
no, it is.
All right, we're not going to argue about that kind of stuff. Do you have any more questions about why we're here?
Yes, Your Honor. Okay.
This might be a good case tomorrow.
Let's see, through 6.
Hope they live stream the whole thing. I think we've seen him before as well.
So we're going back to cell phone. Oh. And you don't remember anybody calling you from the jail?
I do not.
Okay. Have you ever arrested anybody and refused them a chemical test?
No, if I offered a chemical test, no.
If you offered, gotcha, okay. So you get to decide when you offer it to people? Is there a standard policy that the department has?
Yeah, we're getting a little off track here, Mr. Reefers, about why we're here.
Yes, sir. I have no further questions, Your Honor.
Any other questions for the sergeant?
No, Your Honor.
All right, so let's take a moment after the hearing. And Sergeant, if you don't mind, just page through your calls. Just show Mr. Reefers, Mr. Nice, and Ms. Hyatt as far back as your incoming, outgoing calls go.
Yes, sir.
Okay? All right. Anything else for the sergeant?
No other question for the sergeant.
Okay. So we're kind of suggesting that we have a motion to quash about Sergeant Simpson, but not after the testimony, right?
That's right, Your Honor. It's my position that he either does not possess the records because he's asking for detailed, call detailed records, message logs, data usage logs from the carrier accounts. He doesn't have that. You know, he can do what you've ordered him to do, asked him to do, is look at the phone and present what's on the phone. And he's also asked for landline calls and records from the jail at that time, and Deputy Simpson wouldn't have access to that. Maybe telecom would, if any, or maybe even the phone provider or carrier for the landline. And he's asked also for just personal phone records, cell phone records, which don't exist. So it's my position that the records asked for either don't exist or he subpoenaed the wrong person if they do. So
all right, Mr. Reefers, anything on that?
As far as the phone records, Your Honor?
Anything about what Mr. Nice just said?
Well, I understand he can go back through on his phone. The reason we're requesting the records far back for November 9th is to show he either got a call from Deputy Simpson, whether it's, or sorry, Deputy Roberts called him either from the jail, from his cell phone, or from a work phone. That's why we're looking for the records for his cell phone and Deputy Roberts' phone to show that this call existed. Either Deputy Roberts called or he didn't.
Okay. Do you have any records that would show a call between you and anybody at the jail between 1:30, well, we'll say any time that evening? Do you have any type of record that shows a call that would have come into you during that time frame?
Just going back to my call on my phone, it went back to December 24th.
All right. Other than that?
I have no access to that now.
Okay. All right, anything else for the sergeant?
No, Your Honor.
All right, you step down, hang around for a minute so we can go over that stuff after the hearing.
Thanks, sir.
All right. So I don't think I need to rule on what we're calling a motion to quash. He doesn't have them. I don't have to quash something that he doesn't have, right?
I agree.
All right. Go ahead, Mr. Reefers.
Your Honor, you can see the timeline is clear. I've made multiple written requests over many months. I've raised the issue in open court, and yet the critical 1:30 to 4 a.m. intake window has never been produced. The state provided partial clips, but never the full record for the time period when I was requesting a chemical test and Deputy Roberts called Deputy Simpson. Without this footage, the state cannot fairly represent what happened. In addition, Your Honor, I believe there must be internal communication or supervisory notes that address my repeated request for a test and the refusal to provide it. A sergeant or higher would have been aware. Those records would directly confirm what was said and why the test was denied. That's why our subpoena included internal memos and communications, because someone in the chain of command had to document or acknowledge what happened. And Your Honor, if those communications exist, those records are Brady material. If they do not exist, the absence itself shows a failure of proper documentation. Either way, it matters. Additionally, while we're here, I also need to note Deputy Carter is the crash report officer. Her report contains contradictions, white versus black vehicle, the diagram mismatch, altered evidence photos, missing moving items in the vehicle prior to photos. Without Carter's testimony and a corrected crash report, I cannot confront the inconsistencies that prejudiced my defense. Deputy Roberts was a jail officer who made the call to Simpson. Roberts wrote no report, produced no video, and yet he's the one who made the refusal call. Deputy Simpson himself is the one who refused to return to the jail for the test. Respectfully, Your Honor, this case is not about volume of records. It's about one narrow, critical gap, the missing 1:30 to 4 a.m. window. I made clear requests in November, January, May, and again in August, right here in open court. Each time the responses were partial, inconsistent, or marked duplicate. Even today, we still have nothing from 1:30 to 4 a.m. That the very period when I was demanding a chemical test and when Deputy Roberts called Deputy Simpson. That gap is not minor. It goes to due process. The jury should not be asked to decide without seeing what happened in that window. The subpoena is proper and the remedy is simple. Deny the motion to quash, compel production of the missing videos, and compel disclosure of any internal communication or supervisory notes about the refusal to test. Only then can the record be full and fair. Your Honor, all I've asked for since November is a complete, unedited record. Without it, I cannot properly defend myself. That's why this is essential. Thank you.
Mr. Nice, anything additional from the state?
No, Your Honor. Victory swig.
All right, so here's where we're at. I have not yet thoroughly reviewed the exhibits in today's case, which I'm going to do and issue a written decision on this. But here's where I'm at on this, Mr. Reefers. We've sort of been down this road once before, is that, you know, the trap that we have in our modern day society, Mr. Reefers, is that we think that everything is documented, we think that everything is recorded, and then we think that all of those recordings are then preserved. Not all of that always happens, and we have two separate issues. We have one issue is you have requested certain things be made available to you, and you didn't get those. There is a record that existed from 1:30 to 4. It existed at one time, and it doesn't now. And the subpoena is not your remedy in this because this record doesn't exist. If I find that the sheriff's office had a legitimate request from you and they ignored it or did not act within that, that's going to have an impact on your case. But it seems to me that there was a general request that Mr. Sarver archived the stuff that he thought was important at the time, and the rest of it was deleted automatically on the retention schedule. There is no constitutional violation, Mr. Reefers, if in fact that is what I find having reviewed the exhibits. The secondary issue, though, is not whether or not these records exist or whether they can be produced, the secondary issue is what effect that might have on the jury and their evaluation of this case. You can provide the jury with evidence that these records don't exist. That is perfectly legitimate to show contradictions, credibility issues, all of those sorts of things. So you can provide all of that evidence at the trial, but what you can't do is you can't call a witness for the sole purpose of impeaching that witness that is not called by the state. So if Ms. Hyatt calls a witness, Sergeant Simpson, for example, you are permitted to cross-examine that witness on all of these inconsistencies. Maybe there's a policy out there that wasn't followed. You're allowed to cross-examine on that policy. You're allowed to cross-examine on this evidence that existed at one time or doesn't exist, or maybe more reports should have been done. You can do all of those things, but Ms. Hyatt is going to call Sergeant Simpson, Deputy McClellan, and is that it?
No, we'll have Deputy Eastham and Deputy Peters. And then we have the 3 lay witnesses. One will be with the video depot.
So we have these
We
deputies.
also have Deputy or Sergeant Dottie for the test fire. That's all he did, though, was test fire the 2 weapons.
Is there a dispute that they were operable weapons?
Stipulate to that. I mean, I asked him if he wanted to stipulate to the test fire. He indicated that he was not stipulated to anything.
I mean, do we need Officer Dottie to come in and testify that these were operable weapons?
No, sir.
Okay, I mean, that's an element that the state has to establish, that this was an operable weapon, but I don't think that's in dispute. I hate to bring witnesses in for something that's not in dispute, but you don't have to agree to anything at the trial tomorrow if you don't want to.
No, that's fine. I would still ask if we do something with Deputy Roberts. He was the one that made the call, and that's why I want the videos, because I was so clear with him and Synergy that we're at the jail. Roberts even said he wouldn't show up to court. And I was like, you will if you're subpoenaed. He's like, well, if we're subpoenaed, we will. That's why I had them write their names down, because I was requesting this test and nobody was doing their job to listen to me. That's why I want the video. That's why Deputy Roberts should be here as well.
Well, but Deputy Roberts is no longer with the company.
I understand. They could still bring him in to testify to his events and his knowledge of me asking for that request and whether or not he called Deputy Simpson or not at the time in question.
Do you want me to continue tomorrow's hearing
Yes.
so that you can locate
Yes.
Deputy Roberts?
Yes.
Former Deputy Roberts, former CO Roberts, what are we calling him?
I think he's a corrections officer.
He's a
Your
corrections
Honor.
So it'll be former CO Roberts.
Yes.
Is that what you're requesting, Mr. Reefers?
I'm not really sure, Your Honor. I'm just saying, in all fairness, if they're going to move forward with trial, he should be here. He's the one that made the call.
So the answer is yes.
Okay, but he's not on their witness list.
That's why you need a
He's
lawyer.
they're not going to be calling former CO Roberts. If you want to call former CO Roberts in your case, you have to subpoena him. He has not been served with a subpoena, which means he's not coming to the trial because he doesn't work for the sheriff's office anymore.
Your Honor, those subpoenas were issued back on September 2nd. I issued the 5 subpoenas for him, for Roberts, Synergy, Hale, Carter.
But Roberts hasn't been served with a subpoena, right?
When was he?
I'm double checking that, Your Honor. I believe that was one of the ones that said that it was not, he was failure of service back
That's correct.
on.
I mean, back on September 2nd, so last week, Your Honor, he filed them with the court, asked for the clerk to serve them. They typically do so by email when it's a county employee. I don't know if, I made Sergeant Simpson aware of the subpoena by email at the end of last week. I was first made aware of it on Thursday or Friday. It's not as if the subpoenas were sent 2-3 weeks ago.
Do we know when CO Roberts was no longer with the company?
Do you know that? I don't know the exact date, but it was prior to September 2nd for sure.
Months ago?
Possibly months ago.
How long ago did CO Roberts leave the employ of the sheriff's department?
Your Honor, it's my understanding, just in speaking with my client, it's been weeks, possibly months ago.
Okay. Let's find that out when the last time CO Roberts worked for the county.
I can do that, Your Honor.
So he hasn't been served with a subpoena, Mr.
Need a
Reefers.
continuance.
I don't know where he is. Do we know where he is?
No, I don't know where he would be employed.
Mr. Sarver, do you know where former CO Roberts is?
I don't mean, I can check with HR to see if there's a forwarding address, but I can't, not right now.
Okay, let's do that and report back via reply all to the latest email chain. But he hasn't been served, so he's not going to be here for the trial. Do you want to go forward with the trial anyway, or not?
I'm not consenting to moving forward with the trial, Your Honor. I'm just preserving my rights. He's the one that made the call. I'm just requesting that he'd be here to testify.
Okay, well, unless you ask for a continuance, the trial's going to start tomorrow. Do you understand that?
I understand, Your Honor. I don't consent to the trial setting, and I don't consent to any continuance. We're here. We've gone over the issues. The state had the evidence, and now they don't. They've denied me the chemical test. This shouldn't proceed any further, Your Honor.
Okay.
Oh, my goodness. He doesn't consent.
You don't have to consent to the trial starting tomorrow, Mr. Reefers. I don't need your permission to start the trial. But if you want a continuance so that you can locate Deputy Roberts, or former CEO Roberts, if you think that he is crucial to your case, I will grant you a continuance if you represent to me that he is crucial to your case and you want a continuance.
Can I have a minute, Your Honor?
Sure.
Ask for the continuance. It's your duty to locate the witness. Ask for the continuance. He's already helped you out. HR is going to give you a forwarding address. Ask for the continuance. Oh my goodness. As much as I want to see this tomorrow, you've got a case. You've got a case. You've got plenty of avenues for reasonable doubt. Just in what we've heard here, the jury is going to look at this and say, you know, we might have some shady police officers. We might have something that was hidden. This doesn't look right. But without this evidence coming in, a lot of what we've heard, the jury will not hear. Should also file a subpoena with the carrier. Try to get the call records, which she doesn't understand either. Legally Blonde. Be there. The judge is doing everything he can for this guy to help him out. I think he smells a rat as well, but something's not right on this one. You basically got someone who was pulled over, and it's alleged that he was drunk, but the level that they're alleging does not require them to do a test, and then they gets the added charges because he had a firearm when he was drunk, but they never tested him, and he's like, test me, test me, test me. They wouldn't test him. The test might have come back clean. And so this whole thing would drop if he had a test that showed he was clean. There was nothing in his system. But the officers seem to be intentionally charging him on a level where they can get some pretty hefty charges against him because they don't like him because he was belligerent, and then also not afford him the right to get his exculpatory evidence, which would be a clean blood test.
Where are we at, Mr. Reefers?
Thank you, Your Honor. Is Deputy, is it Synergy or Synergy? Am I saying that?
That other deputy, is he still there?
Still employed.
Okay, I was just looking to see if he was served. And Your Honor, I mean, just for the record, I don't know if this will be helpful or not, but we will be willing to stipulate to the fact that the defendant will testify that he made a request to have his, to have a breathalyzer, and that no breathalyzer was ever given to him.
Oh.
I'm not going to stipulate to whether or not a call was ever made, but if he wants to testify that he said he asked for one and he never received one, I mean, I don't have a problem with that portion of it, but I still don't believe a call was ever made. But I can see if Deputy Zinnergy was
Is this one of the subpoenas that was issued last week?
Yeah, and actually they were issued August 29th, and I'm trying to see.
He was served. She's backpedaling. Right at this last minute, when they bring up this other name, she says, "Oh, we'll stipulate that he asked for a test and we didn't give him one."
There was one issued for CO Synergy.
How do you spell that name?
I'm just trying to see if it was served.
Why would you not have served it?
I don't have any other responses back on this in benchmark about any other of the subpoenas being served, although, like I said, Deputy Carter did contact me on August 30th that she received a subpoena, and she was one of the ones listed. So I am assuming, but I don't have proof of that. I don't even have proof that Deputy Carter was officially served, just other than her email, and she's out of town this week.
Oh, man.
Your Honor, I've got the spelling of the name if you want.
Okay.
It's Czinege.
This guy might have been in the wrong. Okay, he might have been like.
Is this a CO or is this a deputy?
Situation.
He's a CO in the jail.
And is this CO still with the company or not?
Apparently
Yes.
he is, yes, Your Honor.
Okay, so we can get him served and have him available to testify if we need him, right?
Yeah, I
We
mean,
can make every effort to do so. I assume he's, I don't know this person, but I can call and say, you gotta be here, as long as he's not, you know, I mean, I assume he's there and working this week, I just don't know, so.
Okay, so you've subpoenaed Deputy Carter.
Yes,
She's
Your
not gonna be here, right? It's just
she's out of town.
How do you?
But as I indicated, Mr. Reefer, you can't call a witness and impeach that witness. If it's a witness that's called by Ms. Hyatt, you can impeach a witness that is called by the other side. You can't call your own witness and impeach your own witness. Do you need Deputy Carter's testimony for other reasons other than just impeaching on the reports?
Your Honor, she was the one that interviewed the witnesses as well, which we have her audio and video that we could use for the impeachment of the witness, but Deputy Carter is the one that moved some items in the vehicle before photographs were taken. She's the one that did the crash report. It is incorrect, and we still don't have the updated one. So however you wish to proceed, I don't want to waste the court's time. However, we need to move forward with it. I just want to make sure that subpoenas have been issued for him.
All right, well, crash reports and narratives, witness statements, those aren't evidence. The evidence is going to be what those people testify to when they come and testify here. If you have a witness statement, you can impeach that witness with that statement. There are certain rules for that, but you can't then call another witness and use extrinsic evidence to use another witness's testimony to impeach one of the witnesses. You can't do that. So it sounds like we don't need Deputy Carter, right?
If the state wants to move forward with an incomplete crash report, I mean...
They will.
I don't know, Your Honor.
Okay, but you understand, Mr. Reefers, the crash report is not evidence against you in the case.
That's the whole reason for the initial call is what they're stating. I'm showing the inconsistencies in things don't match up. I'm trying to stick to the facts of the case of what happened, and I should have been given a chemical test, but we weren't. And the evidence provided doesn't add up with the narratives that they're stating.
Okay, so what else do we have? Anything else?
Nothing else from me, Your Honor.
All right, what is the CO CZAC or what's CO CZAC going to testify to? Sinigi? What's CO Sinigi going to testify to?
He was the one present with Deputy Roberts at the jail when I was requesting the chemical test. They're the ones that wrote their name down on that paper.
Okay, so we're going to have him available to testify on Wednesday.
I'll leave here and go make a call to try to get a hold of him and get him here Wednesday.
Okay. What else for today, if anything?
We also have Deputy Hale that the defendant subpoenaed, as well as, one second, Deputy, Sergeant Cato. I'm trying to figure out, I'm assuming they have been served as well. Is he wanting those as well for witnesses? But I just wanted to make the court aware those are the 5 that the defendant subpoenaed a week ago Friday.
I mean,
I just don't know if they've all been served. I'm just making, if you want me to follow up.
He
to
subpoenaed
make
them.
sure
Why
that
are
they've
they
been
not
served?
served?
And they would be present. I just didn't know if you wanted me to check on that too.
I mean, if it's somebody who is employed by the sheriff's office and a subpoena has been filed, I don't understand why that deputy would not have actual knowledge of that subpoena by now. and that's not necessarily Mr. Reefer's fault. But if we have on Wednesday where somebody has been subpoenaed who still works for the sheriff's office, and other than Deputy Carter, and they say, I'm not available, then
this case gets
I'm going to be upset by that.
Are we eliminating Corrections Officer Roberts now since he no longer works there? He has not been served, or are you wanting us to try to get him served before Wednesday?
We are, Mr. Sarver is going to send us a email sometime this afternoon where he is going to inquire of HR to assist Mr. Reefers in locating him for the purpose of him serving his subpoena.
Okay.
But it's not incumbent upon the state. If former CO Roberts doesn't work for the county anymore, I'm not going to put that on you to either find him or serve him.
Okay.
If they work for the county, they ought to be served, they ought to be available.
Okay.
With the exception of Deputy Carter, who is not available. Okay. It doesn't sound like
I'll just
that crucial
confirm
to me.
that just to make sure, but I will make sure. Okay.
All right. Mr. Reefers, anything else?
Yes, Your Honor, I just reserve the right to continue if these people do not show up with the subpoenas or whatever. Okay, we want a continuance if they had not been served. Thank you.
Well, everybody who you've subpoenaed, who is still a deputy, with the exception of Carter, is going to be available on Wednesday unless I hear back from Ms. Hyatt or Mr. Nice later today to the contrary.
Thank you, Your Honor.
But that doesn't mean.
Yeah, does that include CO Synergy?
Yes.
Yeah, that would be, yes.
Yes.
But will not include
But it does not include Roberts and it does not include Carter.
All right, thank you.
So are we going forward with trial based on those three, Zinergy, Hale, and Cato being here on Wednesday?
Yes.
Okay, we are. Okay, I just want to make sure that we
Once
don't get a
again, I don't need
continuance
Mr.
tomorrow
Reefer's
morning.
permission to start the trial, and I'm not going to ask for it. If he wants a continuance from me, he has to ask me for that, which he has not. Continuing a trial in progress, a jury trial, is very unlikely, Mr. Reefers. You need to understand that. But like I said, if there's a deputy who works for the county who says, I'm not available, I'm going to take a very dim view of that.
Yes, Your Honor.
But if we have a deputy who works for the county who's not in Acapulco or something on vacation, then they're going to be available.
And can we find out, whoever's getting the information on Deputy Roberts, the reason that he had left the department?
Seems like a fair request, right?
If there is one in his file, I can provide it.
Makes sense to just go ahead and provide CO, former CO Roberts personnel file, right? It's a public record.
Yeah, maybe was that in the file?
Or has that already been asked for?
Judge is helping out the defendant.
I don't recall. I don't believe Roberts has that.
We'll get it, Your Honor. We'll get it and email it out. Do you want me to send it to the court as well?
Yeah, put me on that link because I'm going to add whatever data we get to the hard drive, which we may need more space for now. That is the evidence that's been accumulating in the case.
Will do, Your Honor.
Okay. I just want to sum up, Mr. Reefers. I want to make sure, I mean, we have these deputies. You know, the issue is whether or not you were intoxicated, whether you had a weapon, whether you resisted arrest, and whether or not you obstructed official business. And if there's going to be an evidentiary claim in this that you demanded a chemical test, unless it's in the record somewhere, it's not in the records anywhere, right? Unless it's in the records somewhere, you're going to need to provide evidence of that before you can call any witnesses that are going to say that that is unsubstantiated or you can't find it. Does that make sense to you?
Yes, Your Honor, I think.
I mean, you have to testify and say, I demanded a chemical test, and then I will allow you to call witnesses if the state's going to impeach you on that, Then you can call witnesses that may say, well, there was a call made or whatever, but not until after that is entered into as evidence.
Yes, Your Honor. I think is that what the state was mentioning, that they were, since we couldn't get Roberts, they were going to allow me stating yes that I had requested a chemical test.
I mean, are you going to testify to that effect at the trial?
Yes, Your Honor. That's what we've been requesting all along.
Okay. Because you have the right to remain silent at the trial. You don't have to testify if you don't want to, but if you want to present evidence, you're going to have to testify if you want your side of that in. But you don't have to present a side. You can just rest on the state having the burden to prove that you're guilty of this beyond a reasonable doubt.
Yes, Your Honor.
Okay?
Legal
What else?
Blonde, that's funny. A couple of you have noticed I did get a little bit of sun.
So to
over
sum
the
up,
weekend.
we have
I'm a little
exhibits
toasted.
that we
Or
are
toasty.
going to convert to electronic form and send to everybody, A through E. Mr. Sarver is going to make an accommodation to Mr. Reefers and try to locate from HR where Mr. Roberts' former CO might be. And also, we are going to exchange a link that has an electronic format of former CO Roberts' personnel file, which we might as well go ahead and call 9.8.2025/F.
He also filed a motion in limine, Your Honor. I was just pulling this back up. Do we need to discuss any of that?
Might as well.
This is about to limit or exclude portions of Ashley Burns' video deposition that we did.
Okay, Mr. Reefers, you want to be heard on that?
Yes.
Yes, Your Honor. I submitted the filing in there just talking about the inconsistencies in the report based on what she said the initial night.
Goes to the weight of the evidence.
All right, maybe you and Mr. Elter want to have a little bit of a talk between now and the trial where Mr. Elter can educate you on the difference between admissibility and weight. Whether a document or a witness or a piece of evidence or a piece of testimony comes in or not is a matter of admissibility. Is it relevant? Is it properly documented? Did they see what they say? Those issues go to whether or not that is admissible. The secondary issue is how much weight is the jury to give that? And if somebody says, I saw something, clearly they didn't see it, but they say under oath that they did, it doesn't make it not admissible if they're going to testify, but you do have the opportunity to impeach them on their credibility as to whether or not the jury should believe that. Those are different questions. The issue regarding Ms. Burns' testimony, all of that was admissible, but you might have the opportunity to argue to the jury that some of it's not credible. You certainly have that, but her testimony is admissible. You have the request to recall her. I'm going to deny the request to recall her. You had the opportunity to ask her all of those questions. And we've been doing this for a long time. Mr. Elter, Ms. Hyatt, Mr. Nice, back when he used to do this kind of stuff. We all know that after a witness steps down and leaves the room, you think to yourself, oh, I wish I would have asked this or this. That happens in every case. As far as I'm concerned, the deposition of Ms. Burns is ready to play as if she was called as a live witness.
Your Honor, then I would just request that while we play it, we also play the video parts along with Hale and Carter, where they're being interviewed, to show the inconsistencies at the same time then.
I'm not going to do that.
No.
All right, anything else for today?
I think
I have an exit date for former CEO Roberts. His name is Jordan Roberts. He left employment at the Sheriff's Office May 29th, 2025.
Okay.
And I do have an address that I'll give to Mr. Reefers and Mr. Elter.
Okay.
I'll still do the personnel file thing, but we were able to get that by email from the HR.
That sounds great. Okay, what else?
You want me to just submit a copy of everything went over today?
Might as well. All right, we're in recess.
Thank you.
Wow, that one's going to be juicy. Mr. Reifer, he appears to have standby counsel, but I'm not sure if standby counsel is licensed, right? He has a standby smart guy who might not have a law license. Judge takes his iPad and says, I'm out of here. Helped you as much as I could. Leaves the beautiful tufted chair empty. So that one's going to be Wednesday because he didn't ask for a continuance. Why would he not? The judge practically filled out the form for you. Honestly, he did all the work. He required the other side to turn over personnel records. He required the prosecutors to turn over the forwarding address for him. Now you're going to have to serve him with subpoena today to get him here on Wednesday. Oh man, he's going to be like, oh, I have something to do. But standby's the lawyer from the previous case. I don't know. I realize he wants to move forward because the state is not prepared in his mind. But the state, honestly, as much as we don't like the answers we heard, if there's no evidence, it doesn't exist anymore, and technically he didn't ask for it properly initially, that's the way it rolls. That's why you've got to form your FOIA requests or your demands for discovery so carefully and broad. Put it on them. Put it on them initially if they're not going to turn it over or not going to preserve it. And then if you've got initial records asking for it and they didn't preserve it, that's on them. And then you see cases dismissed. Then you see evidence, witnesses thrown out. He's scrolling through his phone right now. Look, this is as far as I can go. As far as I can go. December 24th. It's funny to see him scrolling. Do you believe he only had one phone? The work provides one phone and he didn't have a personal phone? I would say that's rare. Of course, my wife doesn't have a personal phone, so. I think the standby did what Runkle says he does sometimes and heard a person struggling and stayed in the courtroom to help. It's like, look, man, you need somebody to whisper in your ear. He did really well. He did really well for being pro se, understanding a lot. They're still showing screenshots. Heather from Texas, I am so sorry you're getting ads over the chat. This is a new thing for YouTube. I don't get a say in this one. I want to know why they're ready to stipulate. Why, when they bring up is there anyone else that's subpoenaed? They're like, we're ready to stipulate that he did in fact ask for that. Yeah, because they have an officer who's like, yep, that happened. And they're about to bring him in, and that looks bad. Heather from Texas, I do. I honestly do. YouTube takes care of me on the ads. I just wish they didn't interrupt your viewing and chatting experience. YouTube Premium is fantastic, which I love. He clearly does not believe the police officer regarding his phone records. Yeah, I think I would want to know what model of phone it was and when he acquired it. I mean, there are some questions that probably should have been asked. Now they're all talking about the case. Virginia, so now we have to watch ads. Some YouTube puts some ads in, and I can't stop them. I've got the ad automator turned off. That's where it automatically puts in ads about every 2 to 5 minutes. Trust me, that's the only setting I can choose. The only other option is to demonetize my channel, and then YouTube will just put in what ads it wants and not split revenue with me. So, all right. Thought I heard the defendant ask for a continuance. It was improper the way he asked. He said, I'd like to reserve the right to have a continuance if the officers weren't subpoenaed. So we show up on Wednesday, jury's here, and we check and say, did everyone get subpoenas? And they're like, no, we couldn't find so-and-so. Now it's too late to ask for a continuance because a jury has been seated. The judge says, no, I'm not going to do that. But he also didn't want to get a continuance at all. Like he's trying to push the case forward without everything he needs. How exactly is the defendant supposed to ensure subpoenas get served? You hire a server, process server. A lot of sheriff's deputies or officers might do that part-time. Or you can pay them to send somebody out. I think I figured out what the points are for. It's to hype videos. YouTube was asking me the other day if I wanted to use my points to hype a video. Hype is a new thing, Ashley. It's for content creators that have less than 500,000 subscribers, which I just checked, and I fall in that category. I had to check, right? No, I'm well under that. But if you got less than 500,000 subscribers, they're giving you the opportunity to hype your like a couple of videos, like a handful of videos, and that is basically injecting it artificially into the algorithm for people who aren't watching currently. So, and it's not related to the points on my channel because I run that. The points, like you see right here, that is not even connected to YouTube at all. That is connected entirely to Lumia Stream. It's an outside app that I pay a little bit each month for. John Reap. Courtney, I saw this before. I don't know where. Sorry, I just was trying to respond to some emails here. Let's see. Where and when is the John Reap? Guess I should ask what he's charged with as well. Let's see, Catawba County, North Carolina. Oh, it's North Carolina. Oh man. I think that might just be a hearing today. Is it just a hearing? The comedian trial? Amber, get me the scoop. I'm showing North Carolina, but AI might be wrong on this one. And it's showing April 2026 as a trial date. And in Catawba, Catawba, County, North Carolina. I was asking what he was charged with. I don't know. I know North Carolina, because I live here, is not as friendly as, say, like Florida. Oh man, Shannon, we're not covering that then. Nope. I don't have anything on it. I just saw it in chat. But apparently it's one of those cases we don't follow. Virginia, I've chosen not to follow them. You're welcome to watch them. We're just not, we don't follow every trial. We're sort of in a holding pattern waiting to see if a couple cases come forward that we want to follow. We do this between big trials. Can't do all. All right. I think we're done watching what's happening here. Everyone's still talking about the case still, but the defendant takes his red suitcase and leaves the courtroom. He's gone now, so we'll see if that goes forward on Wednesday for that one. Let's see if we have anything else. Going back to, I know Judge Middleton had some stuff going on all throughout the morning. Let's see what he's up to. Oh, we have an interpreter here. Makes it a little harder. This is civil as well.
Okay. This case, as I indicated, occurred in 2021. And
Como había hablado, este caso ocurrió en el 2021.
you posted a bond in 2022 and then you failed to appear.
Usted pagó una fianza en 2022, pero usted no compareció.
Where were you?
And you forfeited the bond. Then you got arrested driving again without a valid license in the other case, 25342.
Usted perdió la fianza por incomparecencia.
We might go to Judge Crum
Y
instead.
luego hubo otro caso.
I'm sorry. My foreign language skills are lacking today. Let's see if we can go to Judge Crum for a minute in Kansas. Let's do that.
Sentence you're currently serving in DOC. I'm going to order you pay the court costs in the case. You'll be given credit for any jail time you've already served on the case. Perhaps you've already flattened your sentence, but that will be determined once the numbers arrive from the jail.
Says, don't be a
Pursuant
lady,
to
be a
State
legend.
versus Robinson, considering the fact that you've been incarcerated and will be for the foreseeable future, I'll waive bids application fee and court-appointed attorney's fees. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date.
Judge Webster's on as well, so we might jump.
Counsel, anything
Also in
else
Kansas.
regarding the sentencing recommendations that I failed to address?
No, Your Honor, thank you.
I don't believe so, Your Honor.
Mr. Morris, do you have any questions?
No, Your Honor.
All right.
All right. If there's nothing further, we'll be in recess. And thank you, Ed Ellsworth, for having him available for us.
You're welcome. Okay, Judge Webster, where are you at? There she is.
Welcome. Mr. Geffrey, did you find your client?
Yes, she's on hold, Judge. I'll bring her in right now.
Okay. And remind me her name, please.
Her name is Crystal Terrones, and I have her on the line right now, Judge.
Okay. Is she on your speakerphone, or how do you have her available?
On speakerphone, Judge. She should be able to hear you.
Hello?
Crystal, I got you on speakerphone in front of the judge right now. Just remain quiet unless Judge asks you to talk.
All right. We
Good
are on the
advice.
record in BU 2023 TR 2161, State of Kansas versus Crystal Lachelle Terrones. Please announce appearances.
Derek here on behalf of the state.
May it please the court, Your Honor. Ms. Terrones appears over the phone in my office and with counsel Nathan Geffrey.
Ms. Terrones, can you hear me?
Yes, Your Honor.
All right. Now, Ms. Terrones, I don't like to do court where I can't hear you or I can't see you or confirm you are who you say you are, but your attorney is an officer of the court, and I'll trust that he knows you and recognizes you are who the voice I'm talking to purports to be. This case comes on for hearing on count 1, speeding 99 and a 65.
Whoa.
Count 2, driving while suspended. Count 3, unlawful display or illegal registration. Count 4, operating a vehicle without registration or with expired tag. Those two are similar but slightly different.
She's a fast
Did you hear
one.
what I just said, Ms. Terrones?
Yes, Your Honor.
All right, Mr. Geffrey, the last hearing, November 15th, your client failed to appear. So why is she not appearing today by Zoom or in person?
She failed to appear last time, Judge?
My notes show that November 15th of 2023, I guess that wasn't last time. That's been 2 years ago, but she's been avoiding a conclusion of this case since November 15th of 2023.
No, Judge, we were here in June.
June.
June 27th, yeah.
I do see by June 25th, she did have you on retainer.
Yeah.
You did ask for this continuance, which was granted. So how does she want to wrap this up at this time?
Judge, Ms. Rones is trying to get her driver's license status back to valid. We'd asked for one last continuance. This is only the second time I've appeared on this case. I know that it's been ongoing for some time, but I'm trying to get her back to valid. I know that that's the most important thing, is that she has valid driving privileges, so that we can get this court case wrapped up, Judge. She's very close to getting that done.
And of what benefit or concern of the court is that? Will that get her a better plea agreement? Is that why that's important to?
That's what I'm trying to attain, Judge. My hope. Obviously, I don't have any confirmation of this from the prosecution, but my hope is that once she gets back to valid, that'll put her in a better position for plea negotiations for her case.
All right. Potentially help her get her license back and keep it back.
Absolutely.
All right. So, Mr. Regier, the state's response to this request for continuance?
Your Honor, the state does acknowledge this does appear to be the second setting where the defendant at least appears in some fashion. If the court is prepared to continue this matter out, the state will be objecting to any additional continuances. It would appear that pursuant to the amended information, counts 1 through 3 refer to an alleged occurrence date of over 2 years ago, so the state is eager to reach a resolution in this matter. And the state would emphasize a timely resolution in this matter.
I don't know about that one.
Mr. Rones, I am pleased to see that you've hired counsel, but I am not pleased that you failed to appear initially and that this has been delayed so long. I am not pleased that you're not here where I can see you. I will, counsel, Mr. Geoffrey, grant your request for one more continuance with the condition that your defendant appear in person at the next hearing. I believe she lives in El Dorado, doesn't she?
She lives in Independence now, Judge.
Oh, does she? Okay. Well, I'm going to order that she appear in person. She's got...
Just don't drive, whatever you do, ma'am. Get a
She has
ride.
quite a few things on her record, but they look like they're more of a civil nature than criminal or traffic. Although I do see this case on there from 23. And then she has a 23 LM, whatever county that is that's pending. Council may want to know about that. And that's just what the Odyssey system shows. But, all right, I will continue this at the defendant's request. Jen, what date? On a Monday, November
24th, Your Honor.
November 24th. And Ms. Rones, you probably better be here in person at the courthouse in El Dorado because of the length of this case, how long it's dragging out. But you stay available to your attorney and be ready to make some progress on that November 24th at 9 a.m. Do you understand that, Ms. Rones?
Yes, Your Honor.
All right. Anything further, Mr. Regier?
Just that the state would have it noted that the state will be objecting to any additional continuances in this matter.
As will the court. Thank you. That is so
As
noted.
will the court.
Mr. Geoffrey, anything further?
Nothing from the defense, Judge. I appreciate your time today.
You're welcome. Thank you for yours, and you're excused unless you have another client on here.
That's all I have, Judge. Thank you.
You're welcome. Mr. Geoffrey and Ms. Rones, the defendant, are excused at this time.
Out you go. Mr. Corbin, are you up?
Justin Corbin, do you have an attorney today? Doesn't look like it. Let's take up Mr. Corbin's case. On the record in 20 BU 2024 TR 3051, State of Kansas versus Justin Allen Corbin. Jared Regier for the state. Mr. Corbin appearing in person and without counsel. Is that right, Mr. Corbin?
Yes.
You're going to represent yourself today?
No. I've found an attorney that I plan to hire. I self-employed. Money didn't come in like it was supposed to. I haven't been able to retain him yet, so I need.
Who is he?
Who is he?
What's the attorney's name that you're going to get the money and retain?
I'm going to go with Patterson.
Darren Patterson?
Yeah.
We've seen him
Have
a
you
lot.
talked to Mr. Patterson about retaining him?
No.
I have not.
So he may not take your case. Well,
Yeah, that's true, but I haven't had the money to retain an attorney yet, so.
well, do you know how much he requires so that you know if you have enough now to retain him?
Well, I got a check that I was waiting on. It took 30 days longer than it should have. Self-employment.
I understand self-employment. All right, Mr. Corbin. This case needs to get resolved. It's over a year old. Driving while suspended, second, no liability insurance, no registration or expired tag. I would feel better about granting your request for continuance if you'd even talked to Mr. Patterson to see if he was willing to take your case.
Mr. Patterson's
No,
on
I
the
didn't
stream
get
a lot.
I didn't get the check until last week, so.
Okay, but if you have money to pay for your own attorney, you should do that instead of the taxpayers. I appreciate that aspect.
Yeah.
All right, so you've got a 24 conviction for speeding and a 26 for speeding. 2009 that's civil. 2010, that looks like maybe you were possibly a victim or a witness, maybe. Here's a traffic in 2010, no insurance, speeding. Looks like that's been resolved. Mr. Regier, do you know of any other cases he has pending in Butler County?
Your Honor, the state is not aware of any other pending matters, although it does appear that previously another traffic matter from 2020 did proceed to trial on stipulated facts approximately 3 years prior.
Welcome to the defense rests.
Maybe that's why it's
Appreciate the read.
seems like there's something more recent. All right. How much time are you asking that we wait for you to conclude your attorney hiring, Mr. Corbin?
I can have it taken care of this month and be ready to come back in November probably.
You know, that's providing you can get Mr. Patterson to work that into his schedule and so forth. All right, we have Mr. Patterson here November 17th, don't we, Jen?
Your Honor, we do, but November 17th is full.
Oh, okay. Well, shoot.
We're now using the 24th.
We're now using the 24th.
Shoot.
All right.
There's another
Mr.
case out of
Corbin,
Georgia.
I'm going to, did I give you a chance to state your position, Mr. Regier, for the record on whether to continue?
He's opposed.
One moment, Your Honor.
Another case out of Georgia involving that 2021 spa shooter. They're going for the death
Your Honor,
penalty.
if the court is prepared to continue this matter over, the state would be objecting to any additional continuances. At best, the anticipated reasons given by the defendant on the record for seeking a continuance appear to be prospective at best. Additionally, in the 2020 case previously referenced, it would appear that matter had approximately 7 or 8 hearings before proceeding to disposition. So the state does have concerns regarding taking advantage of the proverbial system and manufacturing delays, as it were.
The proverbial system?
All right, Mr. Corbin, we're not going to keep doing that on this case. June 25th of 2025.
She may have been the inspiration.
You
I'm
said,
watching you.
well, this says 25. You were here June of 25. It says that you did not believe you'd qualify for a court-appointed attorney and you'd like to hire your own. So we sent it over at your request to September 8th. September 8th, we met by Zoom, and you said at that time you'd like to retain Darren Patterson and asked that we set it over another approximately 2 months to November 24th. Oh, I'm sorry. That is today you're saying that. Sometimes they get their notes ahead of me in these hearings. They're so efficient. She's writing what we did today. All right. But nevertheless, this is 2 times now you've told me you were going to hire your own attorney. Today, you've given me at least a name of the attorney, which makes it a little more credible. But you and Mr. Patterson better get this worked out because I want some progress on this. We're not going to keep continuing this in hopes that you're going to get an attorney.
Okay, I understand.
You can't get Mr. Patterson retained. You better fill out an application just to make sure you don't qualify. But I would much rather you paid for your own attorney than have the taxpayers do that. So like I said,
Yeah.
I applaud you for doing that, but let's make sure it happens then.
Okay,
All right, you have his phone number? Do you need his phone number?
I can look it up. If you have it, I'll take it. I got paper.
He might be on the Zoom already.
316, of course,
867-53. Oh, Judge, you're putting it on the screen. Doesn't help. Yeah.
I think I did, 7700.
Yeah.
Or is it 7070, Mr. Patterson? I always get that twisted.
7700.
7700.
Mr.
There you go.
Patterson's
You
on
heard
the,
it, Mr. Corbin. Give him a call as soon as you can.
he's on the line right
He won't
now.
be available. I've got him tied up the rest of the morning, but he has staff available.
Okay.
If they can't help you,
Thank
then
you,
call
Judge.
back. Thank you. All right, we'll be in recess on Mr. Corbin.
And Your Honor, what was that date for setting this matter over?
November 24th, 8 a.m. Defendant's request continued on bond, same conditions as before, Mr. Corbin.
Thank you, Your Honor.
You're welcome. And we're in recess. All right.
Thank you.
You're welcome.
Court security
Deputy
has a question.
Caulfield, who would you like to take up?
Well, I was just going to let you know, we actually have 3 out at the jail that probably needs heard. I have 4 here, 3 are Mr. Patterson's and 1 pro se.
And Judge, I am ready on the ones at the jail.
All right. Yes, Mr. Patterson mentioned that a while ago, so let's take them up first, Deputy. We can bring the jail in. Thank you.
Who would you like to see first, Mr. Patterson?
How about Elias Quirrell Martinez? And Jared, I sent you an email on that case, if you could possibly look at that.
All right, we'll be on the record in BU 2025 TR 1491, State of Kansas versus Elias Coral Martinez. Jared Regier for the state, Darren Patterson for the defendant, who also appears personally from the county detention facility by Zoom. And Mr. Regier, are there any announcements at this time? Defendant charged with driving while habitual violator and unlawful registration, June 24th, 2025.
Forgive me, Your Honor. If I may request a brief 2-minute recess, at which time I will be in a position to address this matter.
Absolutely. 2-minute recess at state's request on Martinez.
Thank you, Your Honor.
You're now going to watch Mr. Regier download. Oh, he goes off camera. He's downloading all the information to his brain, at which point he'll come back on and be fully versed in this trial. He is so great. Sometimes he'll request like a 20-second break, and that's all he needs. He consumes the data, and then he's back. I have seen Mr. Regier break his flat response look and smile, but it's rare. Love that Mr. Patterson was on the call. Sorry, put a pointer on him. Doesn't sleep, he just periodically makes whirring noises and reboots. Oh, it's going to be 2 minutes on the dot. He's that good. He is quite precise. It's an interesting coffee mug. Regier is hilarious.
Mr. Kentley, I apologize. I didn't see your name before. What case are you here for, sir?
Judge, I believe Mr. Ketley might be here on Jordan Dillon.
Okay, thank you.
He's also in jail.
All right.
Mr. Patterson has activated the blur my background feature on Zoom.
Your Honor, I'm here for Jordan Dillon, who's at the jail.
Thank you. Mr. Patterson advised me of that. Appreciate it.
2
Sorry
minutes
we
are
didn't
up.
get you sooner.
Thank you for the court's indulgence, Your Honor. The state is prepared to proceed in this matter.
And Judge, I'd have an announcement based upon that.
Okay. All right, back on the record in BU 2025 TR 1491, State of Kansas versus Elias, Coral Martinez, all parties as before. Council announcements.
Thank you, Judge. I would announce at this time, Your Honor, pursuant to plea negotiations, that Mr. Coral Martinez will enter a plea of guilty to count 1, driving while habitual violator. States agreed to dismiss count 2.
And that's your agreement, Mr. Regier?
That would be the state's understanding, Your Honor.
And recommendations at sentencing, Mr. Regier?
Yes, Your Honor. Pursuant to plea negotiations, the state is prepared to recommend a $200 fine, that the court impose court costs and make an appropriate determination of attorney's fees, as well as impose a 6-month underlying sentence subject to a year of reporting probation, all standard conditions, including a $60 probation fee. The state does acknowledge that there appears to be an elevated fine pursuant to KSA 8287. However, based off the state's review of the case, the state's information appears to suggest this is not a case where the elevated sentence applies.
Okay, thank you.
He's good.
All right, and Mr. Patterson, you agree that that's the rest of the...
Yes, Judge, this is not a case where the elevated sentences would be applicable. I would tell the court, though, my client has been in jail since June 24. We just asked for credit for time.
And while the state understands that that was not specifically discussed during the context of plea negotiation, the state is not opposed to that being an order of the court if the court determines it to be appropriate.
Thank you. All right, Mr. Coral Martinez, can you hear me? And sir, when you introduce yourself, what name do you use?
Elias Coral Martinez, Your Honor.
You use both names, Coral and Martinez?
Yes, ma'am. They usually put Coral and just hyphen it Martinez.
Okay,
but
thank you, sir.
Coral Martinez. That's my full name.
Appreciate that. Mr. Coral Martinez, have you heard the attorneys talking about a plea agreement on your behalf?
Yes, Your Honor.
And do you agree that that is your agreement?
Yes, Your Honor, I do agree.
How then do you plead to count 1, driving after being declared an habitual violator?
Guilty, Your Honor.
And is anyone making you enter this plea today by any threats or promises other than the plea agreement?
No, Your Honor.
Do you understand that if you accept this plea agreement and you continue to plead guilty, you're waiving your right to a trial, you'll be found guilty and not be able to appeal the conviction?
Yes, I do understand, Your Honor.
And that's how you want to proceed?
Yes, Your Honor. Thank you.
All right. So the state says on June 24th of 2025, you were operating a motor vehicle in Butler County, Kansas. Are you admitting that?
Yes, Your Honor.
And was your license revoked as an habitual violator at that time?
Yes, it was, Your Honor.
Do you remember which road you were on when the officer stopped and cited you?
I'm not really sure. It was a Kellogg, I believe.
Kellogg coming out of Wichita, but running into Andover and Augusta and then Leon?
Yes, Your Honor.
Also known as 54 Highway?
Yes, Your Honor. That's correct.
Okay, so I have an affidavit here filed June 25th of 25 by Butler County Deputy Donald Tharp III. Do the parties stipulate that that would be the officer's testimony?
Yes, Your Honor.
And that would be the state's understanding where this case proceed to trial, Your Honor.
Okay, so Mr. Coral Martinez, would the affidavit be correct that you were pulled over driving in the 300 block of West Highway 54 Andover, Butler County, Kansas?
Yes, Your Honor.
It looks like he has a long list of withdrawal dates for your driver's license. Habitual violator withdrawal June 14th, 2024. Do you agree with that?
Yes, Your Honor.
Okay. All right. Well, I will find I have jurisdiction and that you are freely and voluntarily entering this guilty plea that you know what you're doing it voluntarily, as I said. So I will find you guilty of count 1, driving while habitual violator, and A, non-person misdemeanor, dismissing count 2, the registration violation, as part of your plea agreement. Per that same agreement, your sentence will be a $200 fine, $108 court cost. You've been in jail since June 24th. Have you been able to work since then?
No, ma'am. I still have a stable job. I still have my job waiting for me. So I'll be able to start working as soon as I get out.
All right. What kind of job do you have?
Concrete finisher, ma'am. I've been a concrete finisher for 14 years now.
Okay. And that's a company in where? Wichita or Butler County?
Wichita, ma'am. It's called Bearing Concrete.
Okay. That's a very stable, solid company. I'm familiar with that.
Yes, ma'am.
It's a good job, too.
Okay.
It's a great skill to have.
All right. I'm going
Always
to
in
order,
demand.
in addition to paying a $200 fine and $108 court costs, I'm ordering that you pay $250 towards your court-appointed attorney fees. And I will follow the plea agreement in order that you get a 6-month sentence. You will get credit for time served since June 24th, so you've already served a lot of that sentence. But if you don't want to serve the balance of 6 months in jail, then you better be successful on a 1-year reporting probation. Because you're getting that reporting probation, there'll be a $60 probation supervision fee. So if my quick math is right, you're about 618, owing about $618. How much time do you need to pay that?
I'm going to get a few months, ma'am.
Sure. Tell you what I'll do. I'll let you and your probation officer sit down and figure that out, what is appropriate. I'm going to order that you make monthly payments or payments in keeping with your paycheck, but make monthly payments at a rate to be decided between you and your probation officer.
I will definitely do that, Your Honor. Thank you.
You're welcome, and you must contact your probation officer as soon as you get out of jail. Deputy, do you have the contact number for probation, or do I need to give that to you?
Could you go ahead and give that to me, Your Honor?
Sure, it's 316-322-4153. If he could possibly call them before he leaves jail, that'd be great. He also can go directly to their office, which is in the courthouse at, 201 West Pine? Do I remember that correctly?
That is correct.
All right, thank you, Jim.
Thank you, Your Honor.
Okay, you're welcome. You're going to have all standard conditions of probation, the special conditions that you make monthly minimum payments to be determined by your probation officer. And you are to make every effort to get your license legal. That's going to be challenging because habitual violator usually says you can't do much for 3 years, but
DMB.
Do what you can to get it legal.
Alphabet Cereal was discontinued in 2021, but it will be back this fall in limited quantities.
Yes, ma'am.
All right, I'll let you supervise or transfer your probation if probation in Butler County thinks that's a good idea. They just know how to contact me to get that done. Anything else, Mr. Regier, we need to address?
Your Honor, is the court determined to set when the first monthly payment is to commence for purposes of journalature, or is that also being left to the court services officer's discretion?
No, I'm going to order that his first payment be due October 8th, 2025.
So limited quantities, limited
close of
run.
business, and then on another payment on
Buy
the
up
8th of
everything
each
you
day.
can.
So that'll give you about 30 days, and then on the 8th of each month thereafter, you have an equal payment due.
Thank you.
You're welcome. Mr. Patterson, anything further?
Nothing further.
All right.
She's
Mr.
a good
Coral
judge.
Martinez, anything further?
No, that'll be all. Thank you, Patterson. Thank you, Your Honor. Thank you, guys.
Oh, that's
Appreciate it.
awesome.
You're welcome.
Well,
She's not
welcome,
gonna
and you
serve.
may go at this time, but don't get your probation violated, or you can come back and serve your rest of your sentence.
I will not do that, Your Honor. Thank you. God bless you guys.
Thank you. Bye-bye.
Yes, that's a sticky mousetrap in the corner of the jail down there. Apparently they have rodent problems.
Deputy, do you have another one close at hand?
Your Honor, I have Mr. Culver and Mr. Dillon for Mr. Patterson.
Whoever's closest, it's fine with me.
Mr. Patterson's like, send him in. Send him in. Fall of 2025, Post will do a limited return of alphabets.
This is Mr. Culver.
Mr. Dillon, Your Honor.
Okay, let's take up Mr. Dillon.
And Your Honor, before the court goes on the record, what I will tell the court is the state does believe this matter can be addressed summarily.
I would concur.
We are on the record in BU 2024 CR 239, State of Kansas versus Jordan Jeffrey Dean Dillon. Please announce appearances.
Jared Riggy on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Jordan Dillon, who does appear personally.
And we also have his Community Corrections Intensive Supervision Officer, Ed Kentley, present. Announcements at this time, Mr. Regier?
Your Honor, this is a case where it would appear that an order had been previously filed with the court, specifically in order to discharge unsuccessfully from community corrections. It would also appear that that was filed with the court subsequent to the request for revocation. The request for revocation was filed with the court seemingly on May 28th of this year, with the order of unsuccessful discharge being filed on June 15th of this year. For those reasons, it would appear the request for revocation is a moot point based off the state's review of the case, and the state would move to withdraw the same.
You're withdrawing your motion to revoke. Did I hear that right, correct, counsel?
That would be the state's anticipation, Your Honor.
I trust there's no objection to that, Mr. Patterson?
No objection, Judge.
Mr. Catley, do you believe you can continue with him, or?
Your Honor, this was my fault. He had a warrant to show cause on his felony case and was sent to prison on that. And I was trying to save the court time and actually ended up costing time because I just filed a motion to close his case without not thinking that the warrant had already been served. So this is my fault.
All right. Okay. So it's just a timing situation.
So civil suit
all right,
incoming.
thank you.
Is that what
Then
you're
we
saying?
will
Just kidding.
note that grant the motion to withdraw and proceed as Mr. Regier suggested. Thank you all. Anyone not here on other matters is excused. Mr. Catley, do you have anyone else?
I do not, Your Honor. Thank you.
Okay. Thank
Your
you.
Honor,
Mr.
may I
Regier?
confirm one final point merely as a housekeeping item?
Yes. Go ahead, please. Mr. Regier, go ahead, please.
Thank you, Your Honor. One moment, please.
There have been accusations that he is part Android. He's downloading information right now. He looks so lifelike, though.
Nothing further from the state, Your Honor. Thank you.
Thank you. We are adjourned.
He was
on this
buffering.
matter.
Yes. Love him, though. He's
All right,
really, really
this
good.
gentleman is excused, and we'll take up the next defendant, I believe, Mr. Culver.
Yes, Your Honor.
Okay.
What are the odds of Mr. Patterson being on the line when a
Is
defendant's
Mr.
like, yeah, I'm hiring
Culver
Mr.
in
Patterson?
jail? I thought he was.
He is in jail, Judge.
Okay, he's probably coming in now.
Hello there, sir.
Good morning, sir. Are you Mr. Culver?
I am.
Very well. We're on the record now in two cases, BU 2025 CR 279 as well as BU 2025 CR 362. Each captioned State of Kansas versus Melvin Glenn Culver II, Jared Regier for the state. The defendant appearing in person at the Butler County Detention Facility in custody and with counsel Darren Patterson, both by Zoom from separate locations. Mr. Patterson, any announcements?
Judge, this is a case where I am asking the court to continue this to a subsequent date. I'm also asking, I have received discovery except for one item of discovery I haven't received, which I think is very critical. Both these cases are basically the same kind of charges, violation of protective order. I am asking that the state produce a copy of the order that they believe controls and that is the subject of the protection.
That certainly seems like a reasonable request. Any objection to that, Mr. Regier?
One moment, Your Honor. Your Honor, this is a case that appears to be filed by my colleague, Ms. Norris. I am more than prepared to put a note in the file and communicate with my colleague regarding this matter. Additionally, what I would tell the court is there appears to be a third Butler County case, 25 CR 252. It would appear that matter is presently set for preliminary hearing next month before Chief Judge Rickey.
All right, so in 2025 CR 362, I see one violation of a protective order, allegation date July 29th, 25. Then in the 25 CR 279, I show 5 counts of violation of a protection order, dates occurring June 7, June 8, June 9, June 10, and June 11 of 2025. These are all misdemeanors from what I see. So is the one before Chief Judge Rickey also a violation, and is it a felony?
One moment, Your Honor.
Judge, it is not a violation of protective order. It is a felony case, though, and it is set for preliminary hearing. In that case, the charge is aggravated intimidation of a witness and cruelty to animals.
And is by chance Janet Boyer named as a victim or potential victim in that case?
Your Honor, the count 1 of the information does appear to list that particular individual as a to-wit. Additionally, count 1 is charged as aggravated intimidation of a witness or victim.
Okay. Which
see how fast I switch sides?
Allegedly, Janet Boyer is in these cases. And that's set for preliminary hearing. I don't know that Chief Judge Rickey likes to tag the misdemeanors onto his felonies.
I wouldn't request that, Judge, in this case. I would just ask we set this to the next court date Your Honor has available.
All right. And when is that, Jan, what date do I have available for? Are you wanting control or
control date?
I guess that's about all we can do with misdemeanors. What's our next available misdemeanor control date, Jen?
November 24th.
November 24th, and that is after the date the judge, does that work with the date that Judge Rickey has set on him? Counsel?
Your Honor, as previously indicated, the state's information is that 25 CR 252 is currently set for preliminary hearing on October 8th.
Mr. Patterson, from the defense standpoint, is that okay to set this November 24th after the prelim? Is that a good date for you?
Judge, that's fine. I would also ask court to allow me to file an order for discovery asking for that one item I put on the record.
Absolutely, and I will approve that. Mr. Regier, make sure that that is noted.
I will put a note in the file, Your Honor.
All right, so Mr. Culver, your cases in both of these numbers is being continued at your request to November 24th. You want him to appear at 8 or 9, Mr. Patterson?
If he's out of custody, 8 a.m., I guess, but if he's in custody, we'll work that out with the jail.
Okay, all right.
That is November 24th on both those cases, Your Honor?
Yes, November 24th, and I'm going to say 8 a.m. Unless he's in jail, Deputy, then you and Mr. Patterson can work out his time.
Yes, Your Honor.
All right.
All right, I think we're done with Mr.
Anything further
Patterson.
we need to address from either party?
Not from the state, Your Honor.
Nothing further.
All right, then Mr. Culver is remanded to the custody of the sheriff until or unless he makes bond. And we will be in recess until that date given, and you'll need to reappear then, Mr. Culver. You may go, sir.
you.
Now, do you still have some in the jail, deputy, that you want to bring out?
Your Honor, that's all the in custodies we have this morning.
All right, then Deputy Caulfield, do you want to go to the court security?
Yes, I have Nathan Cervantes, starting with a C. Mr. Patterson.
We are on the record in 2025 CR 230, State of Kansas versus Nathan Cole Cervantes. Jared Regier for the state, defendant in person, and with attorney Darren Patterson. Mr. Patterson, are you ready on Mr. Cervantes' case?
Judge, this is a case where I am not prepared to announce a disposition, that I'm still working with my client to be able to fully make sure he understands the information that the state has. I'm setting up an appointment with him and I to discuss that. Would ask the court to allow us to be settled for one additional time.
Mr. Regier, the state's position.
Your Honor, this is a case where this appears to be the first setting subsequent to the first appearance date back in June. State is not opposed to setting this matter over one time if the court is continuing all prior conditions of the bond. My notes from the first appearance hearing before Judge Hart in June would appear to suggest that the court did specifically orders besides unknown recognizance bond that the defendant have no contact with the victim or the victim's residence, as well as GPS monitoring, and the state will also be requesting the court make a finding on the record that this continuance is requested by the defense for speedy trial purposes.
All right.
The court notes
We're
this
going to bail on this one.
is at the defendant's request.
We're going to go see if Judge Dad has something fun going on.
The defendant is continued on his bond, and with the orders set by the previous judge, June 23rd of 25, you are to have no contact with the alleged victim.
Okay, we're gonna bail on that. Judge Dad is doing some stuff the way that Judge Dad only can do. Let me back up just a teensy bit. Let's see if it's... Oh, he just walked out. Man. Let's go back just a bit. Some stuff was going on here. Hang on. We're going to back up a little bit right here.
Statements, it appears that the defendant was, he claimed that some of the charges weren't his, and we since have received those statements, and everything looks good on our end from what we received from our client.
What do you mean by that? It means that you think that he did use those or make these purchases?
That is correct, Your Honor.
Sir, why should I set aside the default judgment here? Why should I set aside the default judgment?
What does that mean?
I mean, you can't just come in and tell me, Judge, we've been scammed by Publishers Clearinghouse. What is this transaction? RTN direct debit payment Kona, post date August 21, $10,039.91. Can you tell me, counsel?
Direct debit Kona. I am looking at that statement.
That appears to be the source of the complaint, right?
$10,000. $10,000 to Publishers Clearinghouse? You buy one of every magazine they have?
Sir, did you have a Capital One card?
I did. I don't know where it went.
Is it in your wallet?
Are you telling me you did not make this purchase? There seems to be a transaction on August 20 that was posted August 21. Says direct debit payment. What in the world does that mean? It's a Capital One card. Can you enlighten me, Mr. Clark?
I am not sure. I'm looking at the statement that has that from August 20th. I mean, Kona is a common acronym that Capital One NA uses. But I am not sure what that was for. And to be frank with you, Your Honor, I have nothing in notes that came back from the client after the fraud investigation was undergone.
Say that again?
I have no notes from my client post fraud investigation that indicates that is anything that they found that would be indicative of fraud.
Mr. Vasquez,
Yes, sir.
I want you to listen to me. Will you listen for a second?
Yes.
Okay. You're in a courtroom.
Yes, sir.
You remember everything here? Who's this with you? Is that your daughter? Who are you?
A distant relative.
Mr. Vasquez, look at me. This looks like you made a purchase of some kind for $10,039.91 back on August the 20th.
That might have been.
It would have been a 24.
Direct
right?
deposit payment. So Capital One took it out of his bank
You
account.
remember making such a purchase, sir?
Didn't purchase with when I did have that card, and all they did was I couldn't. They didn't allow me to use well, from where they accepted, they said they would give me another card, but they never did.
What did they look into, Mr. Clark? You're saying your client didn't notify it was fraud. This is a strange looking statement. It has one purchase on there for $10,039.51. Now, let's see, went out and bought a used car or something. I don't know what you spend $10,000 on, unless you bought a suite to the Tiger game or something. I don't know. But the point is, go back to your client. Why didn't you respond to this? Sir, can I ask you an honest question? Listen to me. Look at me. Look at me. Do you remember everything? I mean, anybody told you you're having a problem with your memory or anything?
Just that they went back so far.
I want you to listen. Do you remember what you did yesterday and a year ago and 6 months ago? Can you remember all that?
Yeah, it comes up there.
Yeah, I get it. I don't remember everything that happened yesterday either. I get it. Look, counsel, they didn't do their work on this. If they did, they didn't do it very well. I need more of an explanation. I'm setting aside the default judgment. Default judgment is set aside. He's at least raised the issue of fraud. Listen very carefully. I want everybody to listen very carefully. I don't know how you defend this as a layperson. It'd be like me at 83 or 67 trying to give myself a root canal. Not going to happen. He needs to file an answer to the complaint. I'm going to give you 1 extra week. Counsel, will you prepare the order? Defendant has 28 days to file answer to complaint and affirmative defenses. Young lady, he needs a lawyer. I don't have all the answers here. He's not going to be able to do this on his own. And anybody else doing it other than a lawyer is engaging in the unauthorized practice of law. So will you prepare an order saying I'm setting aside the default judgment? Counsel, the defendant has 28 days to file an answer to complaint, affirmative defenses. And I will set this for pretrial. I want to do it quickly. I'll do it quickly. Do you have any money? Where do you work at? I mean, where did you work at?
I worked with I worked with people with, it's difficult to say it. I wanted to just see what was going on. I got a phone call and it was.
Young lady, come on up here,
Yeah.
please.
You can stand right at the podium.
What's your name and what's your relationship with him?
My name is Holly Tiss, Your Honor.
T-I-S-S?
Thisse.
Thisse, okay.
And my husband's grandfather is first cousins of David's wife.
Whoa. Husband's grandfather,
We
first
met
cousin,
them
David's wife.
less than a year ago at church by accident. They recognized our.
Say that again. Say that again.
We met them last.
No, say your.
My husband's grandfather is David's wife, Sally's first cousin.
David's.
What does that make you to him?
Sally's.
Like
first cousin. Okay.
Third cousin, twice removed.
Does he have a hard time recollecting things?
Yes. There is a connection of that.
I sensed that, and I didn't want to.
Yes.
That family tree is not even in the same orchard.
You know where he worked?
And Ford?
Did you work for Ford Motor?
Yes, 39 years.
Okay, so he's collecting a pension.
Yes.
I don't know what else I can do other than what I just did. He's going to need a lawyer. This is sad when I see these situations. Seems like he's being as honest as he can. Somebody's going to have to get him to a lawyer. I'm going to give him 28. I'm going to give him an extra week to answer the complaint. Okay? I don't know what else I can do. And then Linda set this for a pretrial, and I want it set mid-October, okay? You guys can just send out a notice whenever you want.
Okay.
Thank you. I'm really sorry. You seem to be a very nice person to help out like that. Not a lot would do that. I wish you well, sir. Sorry, Mr. Clark. I don't know if I'm doing the right thing or not, but under the circumstances, I think this is my only option that's fair. So that's
it's all good. It does look like that debit. I know we're past the point now. It looks like that debit may have been a charge-off code, because
Okay.
there are a bunch of, it looks like NRA membership fees that have been paid. The balance is built up quickly. It's just that last statement looks a little iffy.
Okay.
So, but yes, this works for my office. This is fine.
Have a good day. Thank you.
I still have two more with you.
Okay, I'm going to go on to these criminal cases real quick. Matthew Glenn Malone, 25B148493. Matthew Glenn Malone, 25B148976. Do I have a lawyer here for him?
Yep.
Okay, Ms. Patillo, your name?
Dion Patillo on behalf of Mr. Malone.
Mr. Malone, your name?
Matthew Glenn Malone.
Detective, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
The two trespassing charges. One emanates from June the 26th. It appears the other one emanates from May the 26th. And it appears as though 23601 and 17707 Telegraph Road were the locations where he was trespassed from. For purposes of arraignment, how does he wish to proceed?
Mr. Malone stands mute and waives reading, Your Honor.
Okay, I'm entering a not guilty plea. Where do you live, Mr. Malone? You still live on Wells Road in Petersburg?
No, it's where my brother lives. I live on the streets.
Slow down. What's your address?
I have no address.
Are you homeless?
Yes, sir.
Your Honor, I can add some context. So Mr. Malone, his mail goes to his brother's house. And that's one of the reasons that he has these, looks like a failure to appear July 2nd, 16th, and the 30th. The mail that was going to his brother's house, Mr. Malone was not getting it. He knew that this situation was going on. He knew he should have called the court. but he doesn't have a address that he lives at. He just has an address that his mail can go to.
The puppet's name is Walter, but yes.
He's not employed. He doesn't have any felonies, no children. I would ask for a personal bond. I saw in the file that looks like there's a $3,000 10% bond and then a $2,500 10% bond. But again, Mr. Malone is not employed. So he doesn't.
I know, but how am I supposed to get a hold of him if his brother isn't telling him the court dates and he's got no address? How are we supposed to get a hold of him? I mean, that's the problem. He's going to tell me next time I didn't get the notice. I was homeless. I didn't know where to go. Right? I mean, he gave us an address. We provided notice there. He didn't show up. He probably has talked to his brother. I don't even need to go there. That's the issue.
So, Mr. Malone, moving forward, would you be able to get to your brother's house to get your mail, actually physically go to his house, or at least?
How far is Petersburg? Where in the world is Petersburg again?
It's down by Monroe, Judge.
I would be able to get down there, yes.
Or at the very least, I also told Mr. Malone he can call the court to check up on, his hearing dates.
All right, we might be jumping out of this one.
Well, we sent these out.
Thurston.
He had a July 2 court date. He had a July 16th court date. I mean,
if he's homeless, doesn't get the mail.
July 16th and July 30th. You missed 3 times. What did you think? You were ticketed by the police. What did you think happened to the file? That we threw it in the garbage?
Can happen.
I was waiting for my brother to get a hold of me, but I had no phone. My phone got stolen.
Jesus.
But I can contact the court. That's not a problem.
Amy Rose, how would you like to proceed?
Detective, what are you asking for?
Your Honor, we leave it in the court's discretion.
They stated they wanted to look into rental assistance, so we would just like the...
She's doing 2 trials at once. Okay, we're going to bail on this one for just a minute. Head up to Thurston County, Washington, where something seems to be afoot. Let's see. Search Thurston County Courts. We might have a trial up here today, actually. Let's go up here.
So for September 17th. How about December 10th?
That makes sense.
Confirmation on December 1st.
Certainly.
And then he's got a scram release condition.
Yeah, and I think he's been on for quite a while, and I don't think he's had any violations or any problems. I'm wondering if, since this is going to, there's just no way to not extend this until we know what's going on with both cases, because he can't sign up for a DP and then go to jail on the other case. So I'm wondering if the court would consider relieving him of that obligation as long as he remains, crime-free, clean and sober.
Is he involved in treatment? Is he doing anything affirmative?
Yes, Your Honor.
Okay. You want to just let me know what that is?
Absolutely. I went to intensive outpatient. I went to relapse prevention. I'm currently in a long-term outpatient program. I also went to inpatient in the month of April, completed the full month successfully. And I'm also receiving random UAs weekly from Friendship Diversion. So I'm still on monitoring.
It sounds like you're doing great. Let me check one of the other courts for just a minute. Let's go over to 4. Okay, 4, we have a motions in limine hearing that's about to begin. 3, I think we're doing. I think this was like restraining order stuff.
It's interesting that he documented also in what he filed is the text message he sent not to just one of the board members of our neighborhood association, he sent it to all of them. Although Ted never received a copy, it looked like he was on the list.
Homeowners Association?
Couldn't find it in his phone. But saying in the text message, don't trespass on my property. And where this really concerns me is, does he perceive that his property extends from his driveway to the mailbox? We have to walk down that city road to get to our community park, which we pay, neighborhood dues to use this gated community park, to use the lake. If his perception is that's his property, then since this event, I've been walking with my phone in my hand, with my camera on in case I need to document anything. And it makes me feel very unsafe. The other really important thing I want to correct is that I stepped, there were back and forth yelling between my husband and Walker. I stepped between them because I am conflict averse and I wanted to de-escalate the situation. And I stepped in front of my husband with my hands down and said, Walker, stop. Just stop it, stop. Because he was approaching us and getting closer. And he looked right through me. He was trying to get his face as close to Ted's as he possibly could to yell in his face. And he didn't acknowledge that I was a human being standing in front of him. He pushed into me to get as close. He didn't touch me with his hands. He didn't threaten me, but he pushed into me to get as close as he could to my husband. And when he says in here that Ted said he was going to throw something at him, and he said, go ahead. I think Ted said, I'm going to call the police. And Walker said, go ahead. We went into that. So there was a long period of time before we made it home and called the police, and the police came and took our statements. And Walker says that he sent the text message right away. If you look at the timestamps, you can see he sent it after the police came. The text message to all the board members. But what surprised me next was when the police officer took my statement, he said, would you like to press charges? And I was really surprised. I was like, what do you mean? He said, well, did he push into you? And he said, yeah, he did. And I said, no, I do not want to press charges. I do not want to provoke Walker. I just want him to stop. I want to de-escalate this. But it was important to document it because this is the third time, and I will say honestly that my husband has told me of Walker yelling at him, and I thought I didn't see it, but I saw it this time. And it was shocking, and it came out of nowhere like a rocket, and it alarmed me. The other thing in here that involves me that I want to correct is there was an occasion where Walker asked me to ask Ted to stop talking about him. That did happen, but actually, and he says in here, he talked to me because Ted had stopped talking to him. What actually happened was we walked out of our house with our dog, which I guess is what we're usually doing when we're walking on the street. And there's Walker waiting out on the road in front of our house. And Ted and I were together. And Walker said, Callie, would you please tell your husband to stop talking about me? And Ted was standing right behind me. And it felt really absurd. I'm like, okay. And I turned to Ted and I said, Ted, stop talking about Walker. Because it was like, okay, why don't you just tell him that? He's standing right here. So anyways, I just think he's misportraying the interactions. There's so many more things that I would like the opportunity to correct, but my husband is extremely friendly. He talks to everyone in the neighborhood, and Walker even says that in here. If you want to know what's going on locally, you ask Ted, because he talks to everyone. That is true. And sometimes he talks to excess. That is true also. And that's yeah. He's also known to walk through the neighborhood with his blower and blow people's driveways off for them. We have an elderly neighbor. She really appreciates it. We have a neighbor with health issues. He really appreciates it. Not everybody really appreciates it. If they say, please don't do that, he doesn't do it.
So he runs his mouth and he runs his blower.
My husband was president of the neighborhood association. I think we were trying to remember exactly 2 years and on the board for at least 3 years. So he's been very involved also in maintaining the community park. He does trim bushes. He loves to do yard work and landscaping, and he doesn't own a machete. I don't know what that's about, but he does have walkers and he does trim bushes.
He doesn't own a machete?
And whatnot.
Well, there's a black mark right there.
He does trim the bushes.
Who doesn't have a machete?
Adjacent to the entry to the park, which also is adjacent to the walker's property. That is true. One more thing about that, I guess I want to say, because this has happened since 4 weeks ago when we came to court to resolve this, and Walker asked for an extension. So after this last incident, which happened right in front of the community park, and we ended the situation by getting ourselves inside the park and locking the gate behind us. And Ted and I went and sat on the dock, which is usually a really tranquil place for us. And we were trying to calm down after this last encounter. I said, you know what? I cannot relax here because you can look straight across and see Walker's dock and his properties right there. I'm like, we need to just go home. And Ted said, we need to call the police. Since then, we were in the park and I was laying on the dock, and George, the dog, came running in and like trampled me as I'm laying on the dock. George has boundary issues. If someone has boundary issues, it's George, but he's an adult male, unneutered dog, and he behaves the way you would expect an adult male unneutered dog.
Unneutered dog. How do you feel about the unneutered
like, what are you
part?
doing in the park? I stood up and I was like, George, go home, George, go. And I walked him to the end of the dock. But instead of George walking straight up to the gate where everyone comes and goes, he walked to the fence adjacent to Walker's property. And I thought, how is he getting through there if he's not supposed to be able to let himself into the park? And a couple of visits later, when I noticed I was not comfortable to go investigate if I thought Walker was home, but he wasn't home. And I went to look at the fence, and it's been unbolted from the post and open, panel's been open so that he can come freely from his own property into the park, where I used to feel safe if I could shut the gate behind him. And know also that an unleashed dog isn't going to just let himself in, pitching out. And apparently there was a so-called incident with a deer that, I don't know, the board's dealing with it, but I no longer feel
That's what boards
safe in the park even, because it's completely open to, it's an extension of his backyard now. So that, when I saw what he said about Ted thinks he owns the park, I just thought, well,
I had something to do that, Aaron.
yeah, I think that was the main things that I wanted to say. Oh, I did want to say something about Ally's declaration. Can we go back and forth, or would you rather finish with me?
Yeah.
Okay. We've been told by several neighbors, again, Ted knows everyone in the neighborhood, and they talk to him. It isn't just him talking to them. They come, they approach him, talk to him. And we've been told by several that Walker had been making the rounds and asking people to make a statement against Ted. And they were like, I wanted to let you know. I said no. I thought it was really weird and made me uncomfortable that he asked me that. But so Ally lives directly, her property kind of faces Walker's and then the park. And she and her husband, Travis grew up in the house, and they purchased it from Travis's dad and his stepmom, and Ted knows the dad really well, but they've retired and moved out of state. But so Ally, she says she's been there about 2 years. And I just have really strong feelings about this, and I'm going to try and stay really calm. But as a mother, what comes to mind is she might not like how Ted delivered the message, but when you're a neighbor, if you feel like there's something unsafe happening in the neighborhood, if you see something, say something. And I'm upset because our daughter used to babysit for Walker and his first wife, Anne Marie. And she spent a lot of time in that house. And when you find out later, it wasn't safe. You feel like you didn't protect your child. And I would want, if I was Allie, I would want to be told. If someone had concerns, I would want to be told. And what Walker doesn't like is that we're friends with his ex-wife, Anne Marie. We're friends with his ex-wife, Bobby Jean. We're friends with his adult sons. And we're friends with them. And he might not like us talking to them, but they're human beings and they have a right to say they don't want to talk to us, but I don't think Walker has a right to tell us we can't talk to them. And we know because of talking to them that they both have had protection orders and that there have been incidents in the home. And I think there's a duty to warn, and if you see something, say something. And I don't always like how my husband delivers messages, but I think it was important to say something when you know that there's a child playing in the home. I do want to say, I don't think Walker would hurt the children. I would hope he wouldn't hurt the children. I'm not saying that he's a threat to the children. I just know, because I've witnessed it, that he has a short fuse and a very aggressive anger, and it's intimidating and it's scary. And I wouldn't want my child to be present when that goes off. That's what I want to say about Alice. Thank you for listening.
Thank you. Ms. Cruz, do you have questions?
Yes, I do, just briefly, Your Honor. I do know, okay, so I want to talk about the most recent incident on July 26th, and I have, I guess, a question for either one, because...
Yeah, right now it's just questions for Ms. Whiteside, since she's the one who just finished testifying.
Okay.
I'm getting in the middle.
Well, I guess, I mean, she's already testified, but Ms. Whiteside, is this the most recent incident that you testified to? Is that the only incident that you have with Mr. Walker in what you describe as acting this way?
With me personally, yes.
Okay.
When he asked me to tell Ted to stop talking about him, he was very calm. I appreciate it.
Okay. So he was calm.
In the other incident, this incident, he was everything but calm. He was enraged.
Okay. And you've known Walker for 20 plus years, correct?
Correct. We knew his wife, Anne Marie, before that, actually, before they moved in the neighborhood. But yes, we've known him.
Okay. And so you've had many, times where you've spoken to him and nothing like what you're testifying today has ever occurred to you.
Well, I will say I don't go out and talk to the neighbors as much. I walk the dog and I say hello to people, yes. And I expect them to be friendly, and I would expect Walker to be friendly. And yes.
Okay, I just want to know that you've had other encounters.
I'm an introvert, and I don't socialize in the neighborhood as much.
Okay, but you've had other encounters, correct, with my client in these about 20 years, correct?
He was never.
Yes, I have.
Okay.
I wouldn't say I know Walker well at all.
Okay.
But I have had encounters.
Okay. The incident where you're saying his dog ran over to you, when was that?
Actually, I'm gonna. We don't need to get into that. That's not going to. Okay, well.
In the last.
No, okay, hold on. That's not going to play into my decision regarding a order between the parties. What happens with the dog? So.
Okay. I don't have any questions for Carolyn.
All right, thank you. Mr. Foshaw, go ahead.
My name's Ted Theodore Foshaw. I'd like to make a couple interesting points. When Walker was interviewed by the police, he said that I had it looked like a water bottle. And Now, in this sworn statement right here, he says it's a wine bottle and I was going to hit him with it.
Okay. It was this.
This is what we'd gone to a concert at San Michelle Winery. This is the glasses they give you. I thought it was cool.
Plastic.
It's plastic. It's light as a feather.
It might have looked like glass.
He had it in his pocket.
And there was about this much. It was a mix of a little bit of wine and
vodka.
Spindrift. And I was like this. Callie's head was here, and his nose was right here in my face, just screaming. And I'm like, Walker, I'm going to throw this at you, meaning get back. I wasn't going to hit him. I wasn't going to, do that kind of thing. But to have somebody spitting, screaming, beat red head and face, going, don't talk to my fucking kids. Don't you get on my fucking property. We're like, hey, we're at the park. Leave us alone. That's what's been like. Prior to that, I'd spent 3 hours working at the park.
His impressions are
Came
pretty
down
good.
with my dog, taking a shower. I'm opening the gate. It's a very heavy, large lock with a too short chain. So I'm fiddling, trying to get it undone. And here comes his dog around the corner. He's a big dog. He's probably 80 pounds. And he's a nice dog, but not to other neighbor dogs. I now know of 2 people that were so. But anyway, this is important because he said in there that I let his dog out. And I said, what? And the dog pushed so hard, it pulled my finger back, trying to get my finger out of the lock and shoved the gate open. I'm like, geez, George, this is what we deal with all the time since he's had that dog. He takes off. I'm like, George, get back here. I didn't know if his dad was in the park or not. So I'm going, George, and he comes around the corner. He goes, did you just do what I think you did? This is how he talks to his neighbor. And I said, what do you mean? George just pushed me and about ripped my finger off. And he goes, yeah, you let my dog out. I said, no, I did not let your dog. He wouldn't quit. I said, fine. I turn around, I start walking away, and he's coming after me. Literally, 2 fists in the air going, I'll fucking beat your head in. I'm like, what? And I'm walking faster. I don't know where the dog was. And in here he says, my dog could get hit by a car. It's a dead-end road, first of all. And said that he's so worried. He keeps coming. I have sworn at him one time. I said, F off. I'm sick of this. That's the one swear word. If he says I swear at him, tell me some of the swear words. I've never sworn. I don't cuss. I don't yell at my kids. I don't swear to my kids. He kept coming. So I turned around and I headed two houses down is the president's home, and her husband was there and she wasn't. I was so shaken, like right now. And I'm like, guess what just happened? Good Lord, I can't believe it. Where's this going to go? I called the police on that. But of note, he talks about the dog being unsafe and that I let him out on purpose. Guess what? Wednesday morning, I had a contractor at my house. We were at the end of it. His tailgate was right on the road, looking at his product sample for gutters. I'm looking over, and here comes George out of our front yard. I didn't see Walker anywhere. I don't know if he was walking.
The dog isn't important.
Well, I realize that, but the complaint is I let his dog out on purpose. Okay. And here's his dog in my yard. Was he worried that he was going to get hit by a car? I don't know. But Walker has a very suspicious nature. He sends me this picture, and it's the neighbor lady who's the president in the park with a contract.
I'm sorry. I haven't seen that, Your Honor.
Okay. So you want to? Okay. Anyway, it's a picture he sends to me. And I said, why are you sending me this? And he goes, you know all. It's because there were 2 gates that went to the side of the lake property that's adjacent to his property. They were always collywobbled, and that's how the dog used to get through. And he was asked over and over. Finally, the board spent $1,000 to have those 2 gates removed. and new fence put in with the metal cleat and all the clips. That's what's been unattached and removed, and now it's hanging over. We just paid $1,000.
Your Honor, I'm going to object to relevance.
And all right, Ms. Cruz, as you can tell, I'm giving you lots of leeway here. So.
Well, the point is a lot of the contention is his dog down on the lake. Another thing that happened recently, his dog jumped in. This leads to Allie. His dog jumped in and he comes at you like this, trying to get you. Big dog. And she had just gotten off her paddleboard. We're coming up to the dock and I'm like, yeah, trying to hold George back. Finally, Walker shows up on the dock and he's like, George, I'm not kidding. He staggers about 3 or 4 times now. I was right here watching it. And I thought, well, that's interesting. Finally, he reaches in, he grabs the dog's collar, jerks him out of the lake, and throws him on the dock. And he stepped backwards like 3 or 4 steps. And I thought, wow. When I talked to Allie, Allie, her little daughter had been down there swimming. She's pretty little.
All right. I don't need to hear everything that goes on in the neighborhood. All I need to hear is what happens between you and Mr. Hughes.
But he's put this in here, and
that's all I need to hear.
Her statement says, I said he's a habitual drunk. I've seen Walker drink beer a few times. He's not a habitual drunk. I never said that. Why would I say that? I just said it's weird. It seemed like he might have been. Anyway.
He might have been a habitual drunk.
Yes, I did make a statement with his custody issue because I knew somewhat of it had been going on. I had heard some of the noises. I had seen some of the things happening, and this was a pattern from his prior 2 boys and their mother. Walker called me one day and said, Ted, give me a ride to pick up the boys. I'm like, well, he goes, I'm at your car. I came outside, I drove him over, pulled up the driveway. He rolled the window down about 2 inches. He leans back and he goes, where are the boys? To Anne Marie, the boys' mother. And she said, Walker, you are 20 minutes late. They are finishing their dessert. She goes, they were out here. And he goes, get them now. And rolled the window up and looks over at me. And I thought, you'd be like that in front of me? So Anne Marie's tone of voice was very strong because of what she's dealt with for years. So I've had 2 neighbors approach us walking in the last couple of days. One of them said, you know that we don't go down the street anymore because George attacked our dog and jumped when our husband picked it up. Yeah. But I didn't go down and say anything about that. If I was so angry and going to run down and give him a bad time around, I don't go on his property. I will tell you, true fact, about 2 years ago after he bought the house, I don't know the exact time frame, and the gentleman that had the person come and do the tree work said, I don't remember dates like that, and I don't want to get involved in the Walker Triangle. But I heard chainsaws. We have covenants in our neighborhood, but the main thing is his property is on wetlands. I walked down there and I said, Walker, what are you doing? And he immediately went into off my property, go, blah, 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 and walked all the way to, and I'm like, whoa, I couldn't believe it. But he clear cut all the way to the lake on land that is not his and on wetlands, which is totally wrong. So have I been on his property? He says I go on his property about 2 years ago. I haven't set foot. I used to blow his driveway. I'd take his garbage cans in, but 4 years. We've been to their kids' birthday parties. And he says that I snoop in his finances. I was at the birthday party one time downstairs.
Ted talks
and Anne Marie comes in and goes, so-and-so's at the door. They send him down. They went into a small room. It sounded like they locked the door behind him. He came out. He had a very old paper grocery bag that had been rolled and was all wrinkly under his arm. He turns around and heads up, and boom, turns around. There's Walker. And he goes, yeah, his friend came by to pick up some books. books.
Okay.
Yeah.
You're getting into things.
But that, see, he says I've meddled in his finance. Like, you haven't been to work in 3 years. How do you pay all your bills? So, yeah.
You know, all I want you, Mr. Poshak, is to tell me why you need a protection order, not all the different.
Because this is the third time this has happened to this level. And I know he's under a lot of stress, financially, emotionally, hired multiple lawyers, fighting another protection order. I get that. That's why we don't want anything to do with him. I was on the board for 20 some years. I went off, and as soon as I got off, they need people. People don't want to be on the board. Walker was there. I wasn't. We were out of town, so he's on the board. So I approached the president and said, do you really want someone on the board that has been arrested for domestic violence? Is that okay to be on the board? And I said, I don't want anything to do with the board. I won't run for the board again until this changes. I've mowed the lawn down there for 7 years. I don't do
Why
anything.
do you need protection from Mr. Yost? That's all.
Because with my wife there and with his son standing there, here's what triggered him. I could see his son standing at the corner like this, witnessing him running over after us. He turned around and started to walk away. And then he turned back and I don't know what he was yelling. It was all so loud. And I said, Bodie, do you see what we have to put up with your dad? That's when he walked away.
Because you're de-escalating?
And then Walker told him, go walk the dog. You just yelled it at him. In the same tone he was yelling at us. And to have him bump into Callie and be right here, that's like, what does it take? The first incident like that, when he came after me, I called the deputy and he said he was going to beat my fucking head in 3 times. And he said,
when did that occur?
I don't have that report right here in front of me. It's in the record. It's through the sheriff's department.
Seems like that was before COVID. It's been years ago.
Not before COVID.
There was no.
Just give me an approximation. A year, 5 years.
Just before COVID.
A few years, yes. But
they're not getting this.
It hasn't been that long. Anyway,
get focus or something.
Focus.
The deputy
Ted,
sheriff
focus.
asked me on the phone. My grandfather's a deputy sheriff. I grew up playing in the jailhouse. Okay. I have great respect for law enforcement.
I grew up playing in the jailhouse.
He said, did he say he would kill you? And I said, no, he did not say he would kill me. He said he would beat my effing head in. Let's have it out. Come on, right now, me and you. And I'm like, that doesn't, I said, can you just go talk to him and say, hey, did this happen? Like, no, we don't have the deputies to do that.
Okay. All right. So
but
there's that incident. There's the incident in front of the mailbox. You said there was a third.
When he came into our drive.
Okay. All right.
Yeah.
Okay. Thank you. Ms. Cruz, any questions for Mr. Poshak?
Yes.
She's not ready. She never thought it would end. She's like,
the incident where you said he came into your driveway. Is that right?
Yes.
Okay. And this is not something that was in your petition. Is that right?
Correct.
Okay. How long ago was that?
Probably 2 years ago. Wouldn't you guess?
I know, time is so weird. We've lived there so long.
We've lived there 27.
I would say, I mean, I think what we're getting at here is.
I'm sorry. Right now it's just Mr. Poshak answering.
Okay.
Just Ted.
But you don't know when it was.
Right.
Okay. Ms. Cruz, go ahead.
But it's been in the 3. Sorry.
Go ahead, Ms. Cruz.
Okay. And will you please remind me what was said in the driveway? Since it's not something that was in your petition, I wasn't prepared.
Say that again.
What was said in the driveway? Your
Just
driveway.
Exactly what Carolyn said, that he did this thing about saying that he wanted me not to talked to anyone else in the neighborhood. The irony of that is neighbors have come to me and said, hey, have you had problems with Walker?
Okay.
That's what's opened the conversation because their dogs have been attacked by his dog.
Okay, so just sticking to my question, right? Did my client come to you and did he say not to have any more contact with him?
He did not say that. He did not ever say don't have contact. He did say don't come on my property, which I've been there 2 years, at least 2 years.
So he said don't come on my property. And what else was said?
I think he made that fairly short and sweet and walked away.
Okay, so he said don't.
At me that day, if that's ruined. No, he did not.
Okay.
Because he's present.
So on that day, the most recent incident, when you are walking on July 26th, you state in your petition, you're walking to kind of this neighborhood park, correct? I just want to be clear that you walked up to Bodie. Bodie did not walk up to you.
Bodie was standing at their mailbox right at the corner. It looked almost like he was leaning instead. That mailbox is about 30 feet from the end of his driveway.
Just to my question, sorry, you went up to my client's son. My son's client did not walk up to you, correct?
Who's 21 years old. But correct. What you have to know, he stops in our yard.
Sir, please, you walked up to his son, correct?
I did.
And this was after you've had prior incidents where he says, stay off my property, where you allege that he said he'll beat your fucking head in, and such. You still went up to his son and felt that was appropriate, right?
I don't have any problem with his son. His son loves us. He's asked us to walk.
I just want to know. And then this is after you made a statement against my client in a family law case involving another child. Is that correct?
My statement against Walker. I didn't make a statement against Walker. What I said is, here's what I experienced.
Okay, you made a statement in my client's family law case, not on behalf of him, but on behalf of the other party involving his child. Is that correct?
I made a statement about what happened between us.
Yeah, obviously.
Okay, and then however, you stated that you have been on his property, correct? Is that right?
I stated I have been on his property.
When there was a tree cutting
I've been in his house and at his children's birthday. My daughter babysat for over a year.
Sir, you walked on his property during the tree cutting incident. Is that right?
Yes, correct.
Okay. And did he kind of guide you off of his property and let you know he did not want you on his property?
Guiding or threatening me?
Did he lead you off of? Did he let you know he did not want you there?
Correct.
Okay. Were you confused by that?
I had not seen that kind of behavior from Walker, but I know he has boundary issues. I know that about his childhood.
Okay, but you're stating that my client has boundary issues?
Yes.
Okay.
Well, he won't leash his dog.
Hold on, sir. Sorry.
He's intimidated many of the neighbors. Those are boundary issues.
Sir.
Yeah.
I don't have any further questions, Your Honor. I just have some questions for my client.
Okay, go ahead.
Thank you. Okay, so Walker, are you there?
Yeah. Do you want me closer?
Yep, I've just got some questions for you. The petitioner here, he's been a neighbor for 20 years, give or take. Give me a quick overview of your relationship and how it's progressed over the years, just quickly.
Oh gosh, quickly, 20 years. Let's see, I've known Ted and Callie for 20 years, and we share a mutual friend who's been friends with their family for more than that. So there was definitely some camaraderie in that sense of, oh, okay, I have a good friend, they're friends. And but I didn't know Ted. And then the first time that I met him outside of the park was at Fred Meyer, and Ted would always talk for extended periods of time. You know, I drive by, we talk through the window, and then at Fred Meyer one time he stepped right in front of my cart and started talking, and I was like, huh, okay. And I just leaned back on my cart and he talked for 45 minutes, and I was just amazed. And then after that I kind of just knew that this was Ted, that this was the man that was going to keep talking. And so after that, I literally would just say, bye, Ted. And I would just drive off or walk off with the understanding that I was being rude and a general respect to most people. But with him, it was a mandatory thing for me to carry on with my day. Let's see. I did split with my first wife, and I was never around when their daughter came and babysat, so I don't even know if that's true, but sure, I don't see why not. And I think at some point, you know, she moved out, I moved back into the house in the hopes of purchasing it, and my name was on the lease. And we had a good friendship. I felt neighborly in that regard. I mean, I pressure washed his roof. As a thank you when I wasn't living there because, you know, I was just being kind, neighborly. But then it kind of shifted. I don't know why or what happened. And it sort of occurred after the time he came onto my property and started yelling and cursing about the tree trimming. And I just was kind of shocked, and I walked him gradually, just as he spoke and I spoke. He followed me. I walked him up to the driveway, and then that was him getting off. And I never cursed at him. But he did ask me at that time, you know, why I wasn't allowing him on my property, and he asked me why I was upset that he came on my property. And I told him then that, you know, you're not in my friend circle, Ted. And he seemed very upset by that. That hurt. I said, you know, you're close. I said, we share a very mutual friend who is. You're just outside but the circle. Talk behind my back. You tell people my business, and I've asked you not to do that, and it continues to happen. And that was the end of that. And it wasn't anybody yelling that I recall, other than when he came onto the property and was cursing at me for having somebody trimming branches on my tree on my property. But after that, he stopped talking to me, and he was very curt and rude. And I saw him and Callie on the dock, and I said, you know, hey, Ted, it's all love, man. Like, just because you're not in my circle doesn't mean like I don't care for you. And he ignored me, and I was like, okay. And then after that, I heard that he was telling people that I was dealing drugs. And I was like, what? And so then I bumped into them as I was walking my dog, and they were walking their dog. And I spoke to Callie because he wasn't talking to me. And I asked her to tell him to please have him not tell people lies about me. I didn't even know about the one he's telling people I'm a drunk. I don't drink, so I don't know what he's talking about. Never been drunk in front of him or anybody. So that was the first kind of like interaction. I didn't curse at him. The other time we were in the lake, I was in the park before him, I guess. And he walked in, I was down by the water. My dog, when he hears the jingle of the gate, he runs, and Ted let him out. And I just walked over and I said, Ted, why are you letting my dog out? You know, and it's at the end of a road, but there's a continuation of a road. There's 5 more houses that have cars coming. So yes, there is a danger for him to get hit by a car. I called my dog back in and I said, why are you letting my dog out? And he started cursing at me. And I don't know why he was angry with me for asking him why he's letting my dog out. My dog is a golden doodle, so I don't know. Anyways, I was threatened at that point. I never went on the other side of the gate. I simply called my dog back in. I closed the gate. He's yelling at me. And I said, do you want to keep cursing at me? Why don't you come back on this side of the gate? And then he walked off, and that was the end of that. As for him getting involved in my case with the mother of my child, that was quite shocking. I don't know why he thinks he owns my house or ever owned my house. That was a little bit weird. He never has.
That part.
What else are we talking about? So then after that, what happened? Oh yeah, we didn't have any contact after that, like nothing. I was like, okay, well, there goes that relationship. And then I heard about him telling my neighbor that I was a drunk, and I was like, this guy's still going on. And then,
to be fair, it was still the same conversation.
What else happened?
Just the most recent incident, really quick, involving your son.
Oh, that one. So then I drove home, and I'm sitting in my car. I'm talking to Russell, and all of a sudden I hear him. I wasn't even going to get involved in it. You know, if he's talking to my son's an adult. Okay, you know, like I'm not going to make a big deal out of it. But then I heard him asking my son where we get our dog groomed. And after him filing his thing with the mother, I didn't feel safe with any information being given to him about my life. And so I stepped out of the car. I walked calmly out. And I said to my son, I said, we do not talk to him. We do not share information with him. Please just go walk the dog.
He's not
at that point, they were very upset that I had interrupted this conversation. And he started yelling at me, no one likes you, you're a fucking asshole. And then I started yelling at him and said, do not speak to my children. Do not speak to my children, Ted. And he started cursing at me, saying I was drunk, saying all these crazy things to me. And I said to him, you need to stop. You need to stop talking to my children. And instead of him just saying, okay, he kept saying that I was these terrible things and cursing at me. And at some point, because I'm yelling at him, he threatened to throw that thing at me. I didn't know what it was, other than it was a cup filled with something that looked red. And at that point, his wife, who had been off to the side, not involved in our yelling, jumped in front of him, because if he had thrown at him, then it would have been assault. And at that point, you know, my friend who was on the phone, Russell, was just like, walk away. And I did. I walked away. I never raised my fists. I never threatened him. I never touched Callie. Yeah. I mean, that was that.
Okay, thank you. Your Honor, I think my client has kind of, he's cleared everything up. I just have a quick closing.
Okay. Just a moment.
Can I respond to his?
In 2 minutes. Right now.
Oh, 2 minutes.
You get 2 minutes.
Okay.
No more than that.
He did not hear me ask his son where the grooming was. As soon as he pulled up, rather quickly, through the door, jumped out, grabbed his sunglasses, and he goes, don't talk to me, stay off my phone. And we're like, whoa. And he goes, Dad, where do we get George trim? And he goes, none of your business. And so did he calmly walk over? No. Was his son worried and concerned? Yes. But I have a concern. He was a witness, and he heard me say, because I could see him stand there, see what we put up with your dad. I said that for a reason, so that Walker could hear that your kids and us are communicating about what you're doing right now. They never interviewed him. But he magically says he had his phone in his hand. He had his sunglasses in his hand. The other hand was open. There was no phone being held up. That's why when we saw this, like, what? You know, I said, did you see a phone? He had his glasses in his hand. So I don't know quite how it happened because it's not clear from the report, but it's interesting to me. An eyewitness you don't interview, but someone who was on the phone, you call them back and hand them the phone and say, here, this guy listened to the conversation. In the original report, they said that Ted was not yelling or cussing at anyone, but something I could tell they were talking loudly or something like that. In the next statement that he signs and sends into court, he says that I was cussing and yelling. And I find it interesting. What did I say? What cuss words have I used? I have not. I did not call him a drunk. I said to her, I don't know, maybe he was drunk and he was really staggering, and the way he jerked the dog out of the lake and just continued to drag him back to the dog.
All right.
So have I cursed and yelled? Did he calmly walk me off the property? Absolutely not.
All right. We've now gone through a number of different incidents. Okay. Thank you. All right. Briefly, Ms. Cruz.
Thanks, Judge. So pretty much what we have here is, I think, the past incidents, like we've heard, they're pretty old, but we're not even precisely sure when. 2 years, maybe 3, who knows, possibly 4. But, you know, I think my client made it clear. He told them, and which the petitioner testified to, he said, he just, you know, kind of said, hey, stay off my property or leave me alone or whatever he said. That was the petitioner's warning. Clearly, it wasn't taken. So we have an incident where petitioner is walking up to my client's property when trees are being trimmed on my client's property, which he testified to and admitted that. And then it sounds like the most recent incident, he stopped in front of my client's home, which, yes, he can have access to the public roadway, that's fine, but he approached my client's child. Keep in mind that he's been known to blow leaves on my client's property. He just testified that he moved my client's garbage cans. He inserts himself in situations, Your Honor. He made a statement as a neighbor. He made a statement in my client's divorce and custody case involving another child. Why would my client want this person, a neighbor, to talk to his son? And just constantly inserting himself. I think we heard today that the petitioner does have a tendency to talk. So, you know, my client saying, hey, you seem to be an individual who likes to gather information and possibly spread it around. He's made it clear, I don't want you on my property. I don't want you, you know, spreading information about me. I just don't want you to be around me anymore. I don't think the petitioner liked that, Your Honor. I don't think he liked that, and I think that caused some rift between the two. But regardless, you know, my client, we submitted a declaration by another neighbor, which I think is very telling, somebody else in the neighborhood, who it doesn't sound like has, you know, a severe friendship with one or the other. So it's somebody that is removed from the situation and has a lot to say about my client being neighborly and about the petitioner having a tendency to spread information and be in people's business. We also submitted a declaration from somebody who was on the phone with my client stating that he heard the conversation, and he did. My client said, hey, don't talk to my kids. Stay clear of my family. You know, my client's not saying they can't walk in the road, that they can't go to the park, nothing. But hey, don't stop and talk to my kids. Don't be on my property. So if anybody's harassed, Your Honor, it's my client. And he, I found it interesting that the petitioner testified today, quote, we don't want anything to do with him. Then why are they stopping to speak to his son? We don't have any report from any of the times that the petitioner stated that he made a police report. He can't tell you exactly what was said in a driveway incident, but and we can't even tell when it was. There's a lot of frankly, Your Honor, and you've heard it, there's a lot of testimony today about a dog. I don't know if the petitioner is angry about the dog, but that is not a reason to get an anti-harassment protection order. And then, you know, I don't know whether or not statements were made about my client being an alcoholic or anything like that. I just want to point out that the petitioner was the one, in fact, out drinking wine in the neighborhood and admitted on you know, giving testimony today, admitted on the record that he would throw a drink at my client. So he is the one today who admitted to threatening. So, you know, Your Honor, my client, he doesn't want anything to do with these people. He is not going to their home. They are coming to his son, inserting themselves in his family law case, coming to his property. He has not made himself available to them by coming to them. So we're asking, Your Honor, to dismiss the petitioner's request today for a protection order. Thank you.
Thank you.
Can I also have?
No. I think I've heard enough here.
We've all heard enough. Let him have it, Judge.
Could I possibly?
No. I've heard enough. Thank you.
Because there is a factual.
I've heard enough.
Judge has heard way too much. Let him have it.
There are two ways this can go based on what I've heard and what I've read. I can enter orders against both of you, or I can not enter either order and say, stop talking to each other. You don't want court orders. That's back. You don't want it. We don't want it. So that's what I'm going to do. I'm going to deny this request for an order. It's very clear. Both have spent an hour now saying why you don't want the other one to have any contact with you. Both made that very clear to each other. I expect you should honor that. To the extent that you don't, then you have the right to say, okay, after this hour-long hearing in court making it clear we don't want to speak to one another, they spoke to me, they come on my property, whatever it is, you can come back and file a request. But we've laid the bright line here. You both have said, I don't want to have you speaking to me. Now, let me clarify a few things. The road is the road. It sounds like a public road. Standing in front of somebody's mailbox is not being on their property. I'll be very clear about that. So I don't want Mr. Yost saying that if there's a pause in front of his house when they're on the public road, they're on his property. That's not accurate. Also, an adult child is not a child. So if the adult child wants a protection order, the adult child can come get a protection order. But in the meantime, Mr. Yost has no authority to direct somebody else not to speak to an adult. So that authority does not exist. It doesn't have to be respected as part of the understanding here. The understanding here is Mr. Yost will not have any contact with Mr. Foshog and Ms. Whiteside. Ms. Whiteside and Mr. Foshog will have no contact with Mr. Yost. That's what we're talking about here. Also, what we're not talking about here is what people say to others about them. So what Mr. Yost says to others about Mr. Foshog, what Mr. Foshog says to others about Mr. Yost, there's no authority in the court at all to restrict what people say to others about somebody. So that's not ever going to be something that this court will consider. So the fact that Mr. Foshog may have filed a petition or a affidavit in a dissolution action, he has every right to do so. The court has every right to hear it, and that should have no bearing on a subsequent protection order request. So all of those things happen, and they are not subject to any court restriction. So I want to be very clear on that. But we will end up being very clear that you both, three of you have said, I don't want you contacting me and vice versa. So that's my expectation going forward. That's why I'm denying the request for an order here, because you're all adults and I expect a very bright line rule you can understand. So that's all we're doing today.
If I'm willing to have the order against me, would you put both into effect?
No, I'm not going to put orders in.
Well, I thought you said that was an option.
It was an option that I was thinking of, but I decided not to do it.
I understand.
Thank you, Your Honor.
All right. And Ms. Yost, Ms. Whiteside and Mr. Foshaw are obviously in court. They'll get a copy of the denial order. If you wish one, you can access it through the district court file.
And what was that, what you were describing that we can do? Do we have an appeal right to this, or what was it you said?
Yeah. Oh, yeah. Of course, you can appeal. Yeah, I did not talk at all about an appeal. What I was saying is you have the right to file an affidavit in a dissolution action.
That's what is that?
That's a divorce.
He's saying you had a right to.
Oh,
right.
Okay, I'm sorry.
Whenever
I thought this was referring to us correctly.
Okay. All right. Thank you all.
Someone's going to be speaking at the next board meeting. I can tell you that. They'll be back. They'll be back. They always are. Wow. What you doing, Ted?
Okay, that's fine. I've made my decision. Thank you, Mr. Foshaw. Mr. Stauffer?
He's trying to talk to the judge. All right. Take your stuff and go. Take your stuff and go. All right. Oh, man. We should stream the HOA board meeting. Oh, that would be great. That would be great. Can we get some cameras in there? It is 1:20. It's time for us to take some lunch. I've been eating a light snack of goldfish, Old Bay flavored goldfish, and water. Probably need something a little bit more substantive than that. But obviously, collard's not on the menu this lunch. We're not going to do that. Judge is saying he needs a Tylenol or two for sure. Forgot this judge's name. I feel sorry. He gets so many of these. He gets so many of these. Are we coming back? Yes, there are a couple things out there. I know you guys are talking about there was a, what was it? Let me look. It was there's one in Fulton County right now that's going on. I think there's some pre-trial stuff going on today for another trial that hasn't been set. There's some things coming up, but nothing I was ready to jump to yet for a big case. So we'll keep our ear to the ground and watch for that. We can come back and do a little bit. I think there's a case in Fulton today that may be starting. There's one tomorrow as well. We've got the one Wednesday. If we want to go back to the court we watched this morning with the pro se guy, he was doing an okay job. But a couple things. Should we portal? I haven't built the next one yet. Let me build it now. That ensures we come back, right? I need to go all the way back to let's go to this one. Come on. All right, and the time is going to be, let's do 2. That worked, 2:15. That'll give us 45 minutes. Make sure you got everything set up. We're good. Reactions off. Slow mode. Okay, done. All right. I'll build the portal right now, and we'll come back this afternoon. Did someone say Judge Boyd had jury duty? She got summoned for jury duty. I doubt she would get actually seated. I don't see that happening. Kim has won the second one as well. Nice job, Kim. Going to regift that as well. Okay. Portal created. Done. There we go. Now we can go to lunch. We have a portal. We'll portal you over. Internet speeds are blazing in Aruba. I thought she would be on the beach. But no, she's in the hotel following true crime. I love it. Oh, man. I was listening while working. I'm so glad I don't live up in Thurston County, Washington right now. Was the judge saying the couple could get divorced? I think he was talking about the divorce proceeding that he testified in. AC's Wildflower, yes. It's going to be Kim R in just a minute. That's good. Filed for a restraining order July 31st. They broke it 10 days later. Yeah. All right, tonight when you go home, please hug the people you love. Smile at someone, even if it's your neighbor with a dog named George. Make today just a little bit better. Please stay safe till we go live again in about 2 hours. Well, no, sorry, at 2:15, 45 minutes. We'll be back. A little more court hopping. We'll be back probably to a new case before the week's over. So we'll see you on the flip side. You guys have a good one. Enjoy your lunch. Bye-bye.
I saw a chicken fight.
There's nothing in the order that restrains you from talking to cats.
I was kick back, taking it easy.
You don't put a diplomatic plate on a hoopty.
Hush! Now I'm trying to have court. You don't raise your voice again.